My lord, may I have my lord's leave, my lord, to mention PLA 367 of 2019. My lord, in this matter, your lordship had granted the probate on 15th of March 2023.
Hmm.
Lord, but the difficulty, what has happened, my lord, in the cost title, my lord, the address is Dover Lane, whereas, my lord, we had by mistake written Dover Lake. So, my lord, for that reason, my lord, the department is not issuing the probate, my lord.
What is the actual cost title in the main application?
The main application is Lane, but it should be Lake.
So it is amendment is to be carried out.
I'm sorry, my lord, it should Lake, but it should be Lane. It's my mistake.
This amendment is to be carried out.
My lord, an amendment application is required, my lord, or just, my lord,
Okay,
clarification will be
tomorrow.
very well, my lord. I'm grateful.
And for the plaintiff, my lord.
And for the defense.
Amendment in terms of A to D is allowed.
Grateful, my lord. Deeply obliged.
Well, this is my section 34 application. On the last occasion, my senior Mr. Somrat Sen had argued and he said that he has concluded. But only one thing, there's one more judgment which we want to cite. But before my learned senior friend comment.
Have you supplied?
No, will just now indicate
Yes,
lordship kindly permits. It's reported at 1999, volume 2, Calcutta High Court notes, page 369. But this is on the point that even in case of an agreement for sale, but I'm carrying a photocopy, my lord, if your lordship would kindly.
You the photocopy.
Then in case of an agreement for sale, there is a requirement of the payment of stamp duty. And in this case, this your lordship will see from the agreement that it can also be termed as an agreement for sale because from the clauses.
Which paragraph you relied on?
And if your lordship kindly takes a look at paragraph 9, 8 to 12. And 15. It appears from the definition of instrument as mentioned in section 214 of the Indian Stamp Act. Instrument includes every document by which any right or liability is or purports to be created, transferred, limited, extended, extinguished, or recorded. On the other hand, according to section 210 of the aforesaid act, conveyance includes conveyance on sale and every instrument by which property, whether movable or immovable, is transferred inter vivos and which is not otherwise specifically provided in Schedule 1 or by Schedule 1A as the case may be. The aforesaid two definitions make it abundantly clear that in order to become an instrument, what is necessary is that by such document, any right or liability is or purports to be created, transferred, limited, extended, or extinguished, or recorded. It is not necessary that any right or interest must be created in the immovable property as contended by Mr. Chapman. Mr. Sajjan in this connection relies on the judgment of 1999 Supreme Court 807 and contends that in the instant case the agreement sought to be enforced, being a pure agreement for sale and there being no clause for transfer of possession either before or immediately after the execution of the said agreement or for delivery of future possession without executing conveyance in respect of property, his client was not required to pay stamp duty as if it was a conveyance. The aforesaid decision of Apex Court was considered with regard to the explanation of Article 25 of the Bombay Stamp Act, when that provision is quoted. Thereafter, paragraph 13. Paragraph 14, in fact. The explanation added to item 5 of Schedule A 1A states in clear term that the expression agreement or memorandum of an agreement, if relating to a sale, shall include an agreement to sell or any memorandum or acknowledgement in relation to transfer or delivery of possession of immovable property with intent to transfer right, title, or interest to such property at any future date. Therefore, in view of such explanation added to item 5 of Schedule 1A, even in case of a pure agreement for sale, where there is no promise to deliver possession immediately after or before execution of the agreement, even if it is mere agreement to transfer or delivery of possession of immovable property with an intent to transfer right, title, or interest to such property at any future date by executing a separate conveyance. Such agreement is to be stamped as if it is a conveyance mentioned in item 23 of the said schedule. This is the portion that even if there is no possession which is being handed over, then also it would be attracting the provisions of it.
Thank you.
May it please, my lord. My lord, if my lord takes the affidavit in opposition, where the agreement is annexed. What is this agreement? Volume 1 কত পেজ? SOD is shown.
Page 90.
Well, it's your lordship will see the affidavit, your lordship. Now, this is also CD form of it. Well, this is the agreement. According to us, the only right in this agreement, we invested money with them. They book. It was called to book a property. We invested money. The only rights under this agreement is my right to get the interest and the returns. It's a very now this document, your lordship will mark page 45 of the AO of the affidavit, and my lord, at page 77 of volume 1, it's annexed to their statement of defense, their counterclaim. They rely on the same document. They have made a counterclaim also. Now, my lord, they are taking this point. They never really urged it seriously before the arbitrator. I'll show that.
Only the thing is that Mr. Ghosh,
Yes.
they have filed an application before the
Yes,
evidence.
they didn't press that. They argued it.
They have, then there is a meeting. It was taken subsequently.
Yes.
After the evidence, it will be taken.
Yes, yes.
That is
No, not after the evidence. It was, yeah, I've seen that. That was after the evidence, after the document had been, that's my last point. If once the document is admitted, you can't take it.
no. When that application was
That
filed,
was
before
made,
the evidence.
no, after, during the cross-examination of the third witness or something.
That application was filed after.
I'll give the dates. It was much after.
Okay.
It was even after their statement of defense. They can't make a section 16 at that stage. It has to be made if you're challenging.
That's why. That is, if it is before
Yes.
or that's after.
So I'll come one by one. Page 77, they have annexed this agreement to their counter statement. So, and they've made a counterclaim on basis of that. This is number one. Now, my lord sees what is this agreement. My lord, Steel Fabs Offshore Drilling, that was the erstwhile name of the claimant, my lord. Now it's NR Oil.
Correct.
But versus Bengal Strachi. And my lord will see that first Steel Fabs Offshore, first party, and then includes its successors in interest. This is important for one last point that Mr. Sen had raised. This will be important. He said that there is a clause which gives us, if I have to dispose of my right in this agreement, I have to first offer them. My right, again I'm repeating, is only to receive money from them on my investment. So it will include that. So it is not that what Mr. Sen argued, that if you are going to, how can you dispose of property if you have not become the owner of the property? So successor in interest, your lordship will note when I come to that point. Then if my lord turns over, what is this agreement about? Well, paragraph D. First is how the first party, the second party got hold of the property. Now D, contemplating good investment prospects in the synthesis building, the first party has offered to invest in, which the second party has accepted on the terms and conditions herein. So this is an agreement for investment. I put in the money. Now then the first party is hereby booking so many square feet in the premises and the rates are given. Now there is no dispute that I have paid the entire 2 crores 43 lakhs. It was there. I have paid that. And I have not sought for that in my arbitration. That is for my payment of the property. When the formal agreement will be entered into, I will get the property. I have only claimed what is the investment or the return I'm to get on the 243 that I have given. So my clause 2, present payment at or before the execution, I was to pay 1 crore 49. I have paid that. Clause 3.
Yes.
Clause 2. Then 3, the balance booked amount, the second party shall call upon them to pay another 3 lakhs odd, not earlier than 12 months. I have paid that also. Then other payments, whatever other payments, this is very important. 4, besides the booking amount, the first party shall pay to the second party as and when called upon to do so. So whenever we were called upon to do so, there is no dispute, we have paid. This will be important on the merits, my lord, because they have said they modified the agreement orally. And they said we have made payment according to the modified agreement. So our answer to that was, and the arbitrators have decided this also, that as and when you made a demand, I was to pay. So I have paid. So the principal sum, there is no dispute. Now, my lord, will come to paragraph 6. Then there is more payments to be made for the car parking in paragraph 5. I'm not placing that. 6 is important. Interest. From the date hereof till the possession date. Now, this possession date, my lord, will mark. I'll come back to it. It's defined. Till the possession date, the present payment will carry interest at the following rate. From January 2007 to January 2008, it shall carry interest of 9.5%.
Correct.
To be compounded yearly, per annum compounded yearly.
Correct.
So the first 149 I pay, I'm to get 9.5%. Then on January, when I pay the next 3 lakhs, the clause B, from January 19, after payment of 3 lakhs, the total amount paid, that is the booking amount, car booking amount, and this 3 lakhs, will carry interest of 11.2%, compounded yearly till the date of possession. This interest will accrue on the account and will be adjusted against the final balance of payment. So now I'm getting 11. One of the points they took in the arbitration, they haven't argued it yet, that 9.5, this claim is barred by limitation. It's compounded interest. Well, I have not claimed that 9 point. Once it becomes 11, that the principal sum includes that. So I'm getting at 11, right, from 2008. Then this clause is very important. Return. The second party shall procure tenants and lessees for the entire booked area by the possession date at the best available rentals, provided the first party receives by way of rental for the entire booked amount a minimum of 13.42% assured amount on the aggregate. So what happens is, after I pay the money, they get a tenant. Possession date is the day they give the tenant. I'm an oil company based in Delhi and outside. But I'm not interested in possession. This agreement only talks about my investment. So when the arbitrators read this, they said, you yourself have made this agreement that they will do everything. They will pay us at 13%. So our claim ultimately is on this 13%, which we have got. This is the return. Then clause 8, the possession date. The date on which the first party will start to receive rentals, not the day I get possession, from the entire booked area to be given under tenancy or lease by the second party. He is to give the tenancy. Will be deemed to be the possession date. Tentatively, it's December. They did not manage to procure a tenant. So they never paid us. And now the assurance in clause 9 is, if they don't get a tenant, they will pay us the 13. That is assured.
Correct.
So clause 9, assurance of second party. Second party is hereby assuring the assured amount mentioned in clause 7 and for the period mentioned in the clause, and in the event the rental receipts of the first party is less than the assured amount, the second party hereby covenants to pay the first party the assured amount and keep the first party saved and harmless and indemnified for all losses, damages, etc. that the first party may suffer for non-receipt. So basically, they have to make up that 13%. Such indemnification might be in the form of capital reduction, achieving up to 13%. So they might give us a discount when I'm buying the flat. Then time is of the essence. Then 11, very important. It is agreed by and between the parties that a formal agreement for sale will be given by the second party to the first party within 15 days of approval and due execution. On approval of the said agreement shall be forthwith executed. So they have to give us a draft of a formal agreement for sale. We have to approve it, and upon approval, the same agreement will be executed. Failing which, the first party, that is me, reserves the right to terminate the agreement and will be entitled to refund of the monies paid along with the compound interest. So now, after this month, this is not the agreement for sale. If your lordship knows that if anyone wants to book a flat, you go and you pay 5,000 rupees and book it. Then I can't make a specific performance suit out of that, nor is my arbitration specific performance. Thereafter, an agreement for sale is entered into. That is to be stamped. This last case my learned friend cited, if I'm creating an interest. Now,
that's why 11. It
Yes.
is agreed by and between the
Yes.
parties. The formal agreement for sale will be given by the second party
Yes.
to the first party within 15
This
days.
hasn't happened. This hasn't not happened. So by
that's
this agreement,
Hmm.
this is an agreement to agree at the best. This is not an agreement for sale. It's an agreement to enter into an agreement for sale. It is not.
Yes.
Now, my learned friend relied on 12 only to show what is the interest. In the event first party intends to dispose of any part or portion of the booked area or the booked car park, if any, the first party shall have to offer the second party to purchase the same at the then prevailing price. This is there, but this, my learned friend said, this presupposes that I have already got a right to the property. This is my right, and under this agreement is to receive 9%, 11%, and then now 13%. And if I don't get the 13%, they had made a mechanism that they'll get a tenant, we'll get the rent from that. But the tenant will be got by him. And then thereafter we will get. And then when he gives the conveyance, then it will be sold to me. That is the understanding. So this clause, my lord, does not create an interest or right in the immovable property, this clause 12, because this was the only one my learned friend really relied on. And the title is not being transferred by any of these clauses. So it's simply the booked area. They usually, the developers may change it. They might say, we're building it, it's come different, you take the other flat, etc. Then there's the arbitration clause. And they have relied on this arbitration clause and made a counterclaim. So this is the agreement. Now, in the statement of in the application section, the 34 application, paragraph 2, they don't dispute this agreement. They can't. I showed my lord that it's there in their counter statement and they've made a counterclaim. Paragraph 2. On December 31, 2006, the petitioner and respondent entered into this agreement in respect of. They don't say it's an agreement for sale, agreement for transfer, nothing. They just keep it as the agreement. Now, their case, I'm going a little bit in the merit. I'll come to the stamp point just now. Their case is basically was before the arbitrator 5, paragraph 5. The agreement was therefore modified in a joint meeting held between the petitioners, which include on 27th February. So they say on this day, we allegedly agreed to delete clause 7, 8, and 9, that assured amount, for no consideration. We have deleted. They forwarded us a supplementary agreement. We refused to sign. And that was that. Then before the arbitrator, they took this point. The arbitrators have gone into the evidence fully and said this meeting, not only was the official representative of the claimant not there, it's in writing, it's parole evidence. It doesn't change the agreement at all. So that is on the merits. We'll come to that, my lord. Then, my lord sees this paragraph 5, your lordship, since your lordship is there, has been denied by us in paragraph 6 of the AO. And that's the case. Then, so what happens is, then they raised a claim on CAM charges. They hadn't given us possession. They said CAM is the maintenance charges. They raised a claim. We didn't pay it because we hadn't got possession. They issued 2 letters, one under the 1956 Act and one under the IBC, the Bankruptcy Code. Both the letters make no mention, that was in 2014 and 2016. I'll show those letters. No mention of such modification. Because even though it's after the modification, they say we are pursuant to this agreement, you are to pay us CAM charges. Those 2 letters are 402 and 403. No? Volume 3, 402. July 16th, 2014. This is after that alleged amendment. So, your lordship, see paragraph 2, pursuant to the agreement of 31st December 2006. And no mention of any amendment. So they say that you are to pay this common area maintenance charges. They didn't file a winding up. Then the next page, 403. This is on 12th April 2017. These the arbitrators have considered also. In paragraph 2, in terms of the agreement of 31st December 2006. On the we have transferred the unit in your favor subject to terms. Now, no proceedings were issued.
Yeah.
This is we have just said that they had made the claim. They relied on these documents to make their claim for CAM charges. No. Then, so then, my lord, going chronologically, page 40 of volume 1, that is my section 21 notice, June 6, 2018. Page 40, volume 1. So the entire thing is there, and finally at page 44, I invoke the arbitration clause and I appoint such and such senior advocate as my nominee. Page 44. Their reply is at page 45. Nowhere in this reply have they said that this agreement is not stamped, you can't look into it, it's not. And they don't also refer to so this is their reply. I'm just saying the stamp point wasn't taken in the reply. I'm just going step by step. Your lordship can take it. Then we file a section 11. They nominate their arbitrator.
What is their reply?
Page 45.
What they said?
They denied, they said that no, this has been modified. We have given you possession. Nothing is payable. And on the contrary, you owe me the CAM charges.
Yes.
When did they nominate?
Then,
Yeah, they did. Then, my lord, we filed a section 11. There was one nominee, they suggested a nominee, and the presiding arbitrator, Mr. Shamsharkar, was appointed. Section 11 application, no point of unstamped agreement, etc. The order is at 1st October 2018, page 140 of volume 1.
yes.
And page 141, your lordship will see, accordingly, Mr. Talukdar is senior advocate, is appointed nominee arbitrator of respondent, and Shama Prasad Sarkar is appointed presiding arbitrator. Page 141. Now, my lord has got that order, 140. At 141, your lordship will see this one. Yeah. If the second paragraph, the third paragraph in 87, in the present case, the existence of the arbitration agreement in clause 14 of the agreement of 31st December is not in dispute. They don't dispute the validity or the existence of this agreement. Now, first six minutes. Yes. Then the next page I want to show, my lord, will just note page 711. This my learned friend also cited, volume 5. This is one of the initial meetings of the arbitration proceedings. No, 400, I think. I'm sorry, not 411. I'll come back to that. Page 400, I think it was. In the first meeting, after we gave our affidavit evidence, we had to open our case. Page 698. I'm sorry, volume 5, 698.
698.
So my chief was over. There was some difficulty on that day. The witness hadn't come. So the arbitrators asked us to open our case. 698. Then my lord will see 699. My submissions are recorded. We had said it's page 700. This is the first two lines I'll rely on. Page 700. Mr. Such and such, learned counsel for the respondent, submits that the agreement of December 2006 is not disputed between the parties. This is after I've given it, after my evidence in chief is over. This is the 6th minute. Now, in my evidence, so they don't dispute it. Affidavit paragraph 4. This meeting was in 2019, the March. In February 2019, the chief had started. That is at page 257. The chief had started. And there were some new documents which were by they were cross-examination was started.
Action.
So this, the chief started in February. Your lordship will see page 179 is my affidavit evidence. And at 180, page 180, the affidavit, the document is tendered and there is absolutely no objection.
179.
It begins at 179, my affidavit evidence. Page 180, this was the procedure of the arbitral tribunal. You give it by affidavit. We gave it by affidavit. Paragraph 4, a copy of the agreement, last line, is tendered in evidence and exhibited.
No objection. Without any
objection. Yes, the demurrer application comes. This is in 2019 Feb. In January 2020. That is the first time they took this point. Page 175. How's it 175? That's in volume 2. The application, the demurrer application they have made. Volume 2, the page numbering is, again, it starts from 700 and 170. So at 175 of volume 2, your lordship will see 15th of January 2020. Long after the evidence was well, my witness's cross-examination was also over. He was also not challenged.
Your evidence is started on?
Yes. Your Lordship has got the affidavit evidence. There was the cross-examination. Then long after that,
Where is this tender? This is the page 179.
no, my lord, this is there in volume 2. It also begins with page 170.
170, their application.
Their application. I was giving the date at 175. It's
Correct.
January
January
2020.
Correct. And 179 is your affidavit in examination. Affidavit
Not
of evidence.
179. My lord, it is at
Yes, that is your affidavit.
700. Affidavit.
When was it? When it was taken on
In February 19.
document?
Because I showed my lord the 6th minutes. That was February 2000. That was March 2019. By that time, the chief had been over, and their advocate submitted.
No, that's why. When this was tendered, 179.
Yes,
This is
I'll show
evidence. When this evidence was tendered before the arbitrator.
When was the evidence tendered? I'll tell my lord. The first minutes is there, then I'll check. Yes. Page 257, 13th of February 2019, volume 2. So it was tendered before that date. I'll give you, my lord, the minutes on which the affidavit was tendered. My lord, page 695, 13th of February 2019. 695 at volume 5.
695.
695, volume 5. Bharpur. 695. The claimant has produced its witness whose affidavit evidence has been filed today. Then, my lord, before examination of the witness, Mr. So-and-so, learned counsel for the respondent, informs the tribunal that on instructions from his client, he does not admit the correctness of the following documents. That document, my lord, is only these documents. That is why I did chief and proved these documents. The document, which is CD2, CD2 is not disputed.
Is not disputed.
Then, my lord, once the evidence was continuing, then my lord will come to 711 of volume 5. 711. This is when they first make this application. Page 711. This is my witnesses, my 2 or 3 witnesses are over. Then Mr. Sen, appearing for the respondent, concludes examination of chief of RW1. Your Lordship has 711,
Yes.
14th of February 2020. Then Mr. Ghosh, etc., starts cross-examination, does not conclude. Then if my lord turns over the page, at today's hearing, the respondent filed an application contending that the document of 31st December is not a registered instrument and is that on the ground that it is insufficiently stamped. On that basis, the reference is not maintainable. Then I took time to file affidavit without prejudice to the contention that the application is not maintainable. Because, my lord, after the statement of defense, you cannot take out a section 16 application or this sort of application. It is agreed that the application will be kept in abeyance and witness action will proceed. It proceeded, then argument started. Now they made an argument before the.
Now, what is the point taken in the cross-examination with regard to the agreement of your PW1?
My witness is not asked a question. This is coming the first time when Mr. Sen comes in to the thing. Afterwards, he has taken this point. The horse had bolted, if I may use that expression by then. My 3 witnesses not questioned on the stamping, registration, nothing. No questions. It's coming in 2020. Mine began in 18. And this was really, it was not pressed. Now, my lord will come to the application where the award is. I have got some other portions of the award I'll place, but before the first thing, since we are on this point, page 50 of the application, paragraph 34 of the award of their application. It's so yes. Page 50, paragraph 34. It's internal page 25 of the award. If my lord sees the award. Yes. And this has been dealt with.
Internal page?
Page 50 of the petition, paragraph 34.
Yes.
The respondent's last argument, this is a very important one, argued with least gravity, relates to the admissibility of the agreement, dated 31st December, on the ground that the document seeking to transfer an interest in land should have been properly stamped under the provisions of Section 35. And registered under the provisions of Section 17. This is what my learned friend has argued before my lord. Neither of the said contention is tenable. First, the document has been exhibited and relied on by both parties without any objection from either party at the outset. My lord will note this is Section 36 of the Stamp Act. If once it goes in, that objection they cannot take. Secondly, the agreement itself provided in clause 11 thereof that the parties would enter into a formal agreement for a sale subsequently. Hence, under Section 17(2), it is not necessary to have the agreement registered. So 2 points, my lord. Not only on the basis of law, I'll support this, that Section 36 and the arbitrators have considered it. It's a point of law in the domain of the arbitrators. They have decided this point, so this point cannot be taken in the 34. And in the 34, they have not taken this point. Nowhere, not a whisper. My learned friend tried to bring it under the umbrella of patent illegality and public policy. He's saying that those are there, I can always take the point. They took the point, and his submission was the award is silent on this issue. I made an application, that application is still pending somewhere. Mr. Yes. Shorkar has passed on, but now my lord will come back to the beginning of the award. I'll just show my lord how the arbitrators have interpreted this agreement as an investment agreement. And that interpretation of the agreement is also beyond my lord's purview under 34. So I can, shall I continue? I'll take another at least 40 minutes.
11 minutes, get up. 11 बजे का है अभी? 11 AM matter is there. Then I am fixing on next date. Or you can come at 12.
12?
At 12.
Yes.
Both the party, 12 you can.
I'll show the award and then I'll deal with the judgment. 12 o'clock.
Before your lordship calls item number 4, 11 o'clock, just taking advantage of the fact it's me only here. But item number 4, I was just to conclude the arguments, my lord. Will your lordship fix it for any day, my lord, when it can be just concluded? Mr. Banerjee, Mr. Aurik Banerjee was also addressing, he had taken the point.
Okay, let's see if today time permits, I will take the matter. Yes, call the fixed matter.
My lord, in the deposition on the last day, there are some corrections.
Yes, what is the correction? Inform the other side. If both the parties are concerned, then we'll correct it.
Question 39.
Joy Prakash Laha. Helera bolo.
Well, I'm showing him a document shown PD8 at page 222 of the judge's brief of documents. I'm showing the original manner.
Yes.
What is this document?
এটা হচ্ছে হায়ার সেকেন্ডারি পাসের ডকুমেন্টস
It is the mark sheet which is
মার্কশিট
saying that I have the qualified in the
Ah.
weighted exam.
হ্যাঁ
হ্যাঁ, বুঝতে পারছি। উনি আপনি ট্রান্সলেট করে দিচ্ছেন। In this document, what does the handwritten cal not bracket SPL against role indicate?
এটা হচ্ছে আমি ক্লাস 12 একেবারেই ডাইরেক্ট পাস করতে পারিনি, 3বারে পাস করেছি কম্পার্টমেন্টাল।
Has qualified the HS examination in 3 attempts. It is written as a insurance.
Shall not present.
Shall not bracketed present. SPL. SPL.
Well, it's the original, it may be tendered.
What was the Indian exhibit?
Because this document, he is not the originator, and neither has he issued this document. This cannot be tendered.
Well, this is the higher secondary original certificate which he has received, my lord.
That cannot
My-
be tendered.
Do we have to call the ICSC board, ISC board?
I'm not going to advise my learned friend as to how it is to be tendered, but this can't be
Lordship,
tendered.
Why it is not, it cannot be tendered?
Well, I'll indicate why. This, firstly, is not a public document. Secondly, my lord, he is neither the originator of the document, nor has he issued the document. As far as the contents of the document, well, it's just a certificate which has to be certified from the board. There's a procedure under the Evidence Act that has to be followed.
This is one of a public document, has been issued by the West Bengal Council for Higher Secondary.
There's a method of certification of this.
Certificate of the board cannot be proved by the calling the board. It is the person who is having
Yes,
the.
who has it?
My lord, there's a method of certification
Huh.
of this by the board. That has to be, that is in terms of, my lord, the Evidence Act.
Deny it in the cross examination.
Well, I don't need to deny it because it's his document. He has to prove there's a procedure.
This is the original certificate, everyone has it, my lord.
Maybe, but that will not go into the record. It can go in subject to objection. My lord.
Okay, that can be done. Exhibit A with object.
So after graduating, higher secondary, what employment or job did you take up? বুঝার নাই।
পাস করার পরে কি জব করেছে, কি কাজ করেছে?
কিছুই করিনি, বাড়িতেই ছিল।
I was unemployed and I was in my house only.
Did you try to get any job or employment?
আপনি কোনো কাজের জন্য চেষ্টা করেছিলেন?
এই এডুকেশনে কেউ দেবে না।
No one. All English educated person.
So in that event, since you had no job, how did you manage your finances after you graduated higher secondary?
আপনি কোনো জব করতেন না, তাহলে আপনার বাড়ির খরচা হচ্ছে আপনার সদস্য কিভাবে দিতেন?
বাড়ির খরচা তো বাবা করতো, বাবা দিত, বাবার আমার পার্সোনাল খরচা বাবা হাত খরচ দিত।
My father used to run the by his own, and my father used to give him some pocket money Yes, Mr.
What
Kapoor,
was your
is
father's source of
any
income?
matter? It will take some time.
What was your father's source of income?
বাবা বাড়ির ভাড়াগুলো পেতেন, ওইটাই আয় ছিল।
Room rents, na? Rent. Room rent. Rent, and that was the source of income. From which properties did your father collect rent?
6 নম্বর পেট্রোলিয়া স্ট্রিট এবং 10 নম্বর কালীপ্রসন্ন হ্যাঁ পেট্রোলিয়া স্ট্রিট, 10 নম্বর কালীপ্রসন্ন সিংহ স্ট্রিট।
How much rent did your father collect? Do you know?
না আমার মনে নেই বাবা কি কালেক্ট।
Were you aware the of how much rent was collected by your father?
না,
When did your father die?
2010 সালে।
2010. After your father's death, how did you arrange your finances, manage your finances?
তখন ওই তখন ভাড়াটেরা আসতে শুরু করলো এবং আমাকে আমার সঙ্গে আমাকে চেক দিতে শুরু করলো।
Tenant used to pay the rent through check to me.
So what was the amount of rent that was collected by you?
ওই সময় মিস্টার রাথির মাধ্যমে জানতে পেরে আমি 6,000 সামথিং পেতাম।
Who is Mr. Rathi?
6 নম্বর পেট্রোলিয়া স্ট্রিটে যাকে লিজ দেওয়া হয়েছিল।
What about the rent from the 10 Kali Prasanna Sinha Road property?
ওটা ওখানে 6,600।
So, have you ever visited 6 Pretoria Street property?
না যায়নি।
Then how did you collect the rent?
ও ও এসে দিত, ওই মিস্টার রাথি এসে দিত।
Where did Mr. Rathi come to give you the rent?
ওই আমার বাড়িতে বাঙ্গুরা ভেন্যুতে।
So who else were the tenants at 6 Pretoria Street?
আর কেউ ছিল না।
Are you aware as to the size and the area of what is the size and area of 6 Pretoria Street?
একটু আমি জানতাম না, মিস্টার রাথি আসার পর ওনার কাছ থেকে জানতে পারি। 38 কাঠা।
Who is Krebs and Sai India Limited?
প্রথমে আমি জানতাম না যে সাই ইন্ডিয়া লিমিটেড, কিন্তু পরে রথির মাধ্যমে জানতে পারি ও রথি ওদের সাবলিশ করেছে।
As he has subleased the property to Krebs and Sai. পুরোটা বলুন। So how was your relationship with Mr. Rathi?
উনি বলেছিলেন আমি দেখাশুনো করি, সুতরাং আমি যদি তোমার সঙ্গে সম্পর্ক না রাখি, কোন রকম ভাবে এই সম্পত্তির আয়ও পাবে না, কিছু পাবে না, আমি তোমার ভালো চাই। আর আমি এই সম্পত্তিটাকে নষ্টও করে দেবো।
ঠিক আছে, আমি What do you mean that the property will be destroyed?
মানে বাবার সঙ্গে তখন তো চুক্তি করেছিল নানা রকম আইনের পথে, উনি জানতেন। তখন তার আমি আইন জানতাম না, আইন তো পরে জেনেছি। আমি আইন জানতাম না বলে অনেকেই ভয় দেখায়, সেরকম ভয় দেখিয়েছি। I was not aware of the law and he was aware of all the law, and the agreement was between him and my late father.
He's saying there was a lot of litigation, not between them.
There were a lot of litigation.
There's a lot of litigation.
আচ্ছা,
Agreement where we bond and
না, বাবার সঙ্গে তো আগে চুক্তি হয়েছিল নিজে, কিন্তু উনি বললেন যে
Let repeat the question.
হ্যাঁ,
confusion হয়ে যাচ্ছে।
ঠিক আছে, সেটা আমি বলছি।
No. What is the question?
Just repeat the question. What do you mean by saying that property will be destroyed?
ও যেহেতু 1971 বাবার সঙ্গে চুক্তি করেছিল, পরিষ্কার করে তাহলে বলি, আর বাবার সঙ্গে চুক্তি করেছিল আমি 1964 আমার জন্ম, তখন তো আমার অবশ্যই 64 আমার জন্ম। ও না, ও 71 ও করেছে, আর আমার 1964 জন্ম ছিল। 64 শুধু আমার পক্ষে, ওই সময় জানা সম্ভব নয়। হ্যাঁ, সেই জন্য উনি বলে
Initially, agreement entered between my father in the year 1971, and I was born in 1969. 64. Yes. Then
আমার পক্ষে তো অত আইন জানা সম্ভব নয়, পারিবারিক গন্ডগোল জানা সম্ভব। হ্যাঁ,
what is stated?
and about the family dispute.
সেই জন্য ও ভয় দেখিয়েছিল যে আমি কি অনেক কিছু জানি, সুতরাং
So that he knows many things.
সেই জন্য তোমার সম্পত্তি তুমি আমার সঙ্গে যদি সম্পর্ক না রাখো তাহলে পাবে না, নাহলে ডিস্ট্রয় হয়ে যাবে।
That is the reason why he threatened me that if I don't maintain the property, the property, and he will destroy my property.
He will destroy me. The property will be destroyed. He will destroy Bolini. The property will be destroyed. Translation is so difficult. So how did you maintain a relationship with Mr. Rathi? So how did you maintain the
কারণ
relationship?
আমার তো আয় ছিল না, এই জন্য ওই টাকাটা, তো ও যে টাকাটা দিল সেটা অবশ্যই আমার কাছে তখন সোর্স ছিল, একটা মানে পয়সার সুযোগ ছিল, তাই
Actually, বলে দিলে, and at that relevant point of time, I had no source of income. The amount which was given to me by Mr. Rathi was a source of income.
Was my source.
সুতরাং অবশ্যই দিয়েছিল। আর দেখলাম যে অত বড় প্রপার্টি মানে মেনটেন করতে তো অনেক খরচ আর অনেক গন্ডগোল, তাই বললাম অযথা ফাঁসিয়ে লাভকে। এই প্রেসারের রোগী, প্রেসারে সুগার নানা রকম রোগ আছে তো, আমার প্রেসার আর সুগারের নানা রোগ আছে তো, সেই জন্য আমি ওর সঙ্গে সম্পর্ক ভালো করে রেখেছিলাম আরো।
So I had to as the property was used property and property was bought, and it was as well as manage the property, and I was also suffering from sugar
and pressure.
That is the reason why I maintained a good relationship.
How was your relationship with the other branches of the law family?
Our family is almost there are
Law, ekdom law.
law family is almost there are সদস্য বা কাকাতো দাদা তাদের সাথে কিরকম
আমি ছোট বয়স থেকে দেখে আসছি বাবা কেস কামারিতে জড়িত ছিল, যার ফলে কার সঙ্গে সম্পর্ক ভালো ছিল না।
Since my childhood, I have seen my father entering into various litigations or involved in various litigations, and that is the reason why he did not have good relationship
হ্যাঁ,
with all the other families.
হ্যাঁ, কিন্তু বাবা মারা যাওয়ার পর আমি ওগুলার ঘাঁটিনি, যার ফলে এখন এমনি যাওয়া আসা আছে।
After the death of my father, I did not go into those matters. That is
I do not
I have not
pursue those
pursued.
litigations.
I
Pursue
not
those
pursued.
litigations,
but I
and the relationship has become better. Say, ठीक है? हाँ, our relationship has become better. Other branches বলে একবার আনসারটা বলে দেবেন? Who did your father pursue these litigations against? No, your father was involved in litigation against whom?
তার বিরুদ্ধে আপনার বাবার মামলা
ফ্যামিলি মেম্বারদের বিরুদ্ধে, অন্যান্য লোকের বিরুদ্ধে, আমার মনে নেই।
the family members and other
হ্যাঁ,
persons.
আমার আর মনে
I cannot say.
I cannot select the person.
what is your right over 6 Pretoria Street, Kolkata property?
আমার বাবা প্রথম কথা আমি জানতাম যে এক ছেলে হিসেবে আমার একটা অধিকার তো আছেই।
First of all, I knew that being a son of my father, I have some right.
আর
I have some right.
কিন্তু 2000 সালে বাবা আমাকে প্রপার্টিটা গিফট করে দেয়।
In the year 2000, my father gifted the property to me.
How did he gift it to you?
Sir, it
গিফট একটা গিফট করে গভর্নমেন্টের ঘরে কি একটা গিফট হয় রেজিস্ট্রি অফিসে গিফট করে।
by the gift
ডিড গিফট করে রেজিস্ট্রি অফিসে।
by way of a gift registered with the government registry office. If they registered
Before the concern authority.
registry office.
Do you have that gift deed with you?
আছে আপনার কাছে?
না আমার কাছে নেই।
No.
So where is it?
কোথায়?
ওটা মিস্টার রাথিকে আমি দিয়েছিলাম আইজিআর বলে ওই যে কি একটা থাকে, হ্যাঁ আইজিআর বলে যেটা কি একটা থাকে সেটা দিয়েছিলাম। যে উনি যখন বললেন যে
I have handed it over to
I've handed the IGR.
IGR to Mr. Rafi.
কারণ উনি বললেন যে আমি ছাড়া তো তোমাকে গভর্নমেন্টের ঘরে বাবা যৎ সামান্য দিয়ে জমাটা দিয়েছিলেন।
আমি ছাড়া কি বললেন?
না
As Mr. Rafi
হেড আমি ছাড়া এটা তোমার তুলতে পারবে না কেউ।
you cannot procure that deed. You cannot procure that deed without his help, without his help.
Mr. Rathi said, I cannot procure the deed
Without his help.
I cannot procure the said document without the help of Mr. Rathi.
As my father has a very poultry shop,
হ্যাঁ 5000 সামথিং দিয়েছিলেন মনে হয়।
5,700 around.
Who did your father make such payment to? এটা তো জিজ্ঞেস করলাম। Who did your father make such payment to?
এই পেমেন্টটা এই যে 5,700 টাকার কথাটা বললেন, এটা আপনার বাবা কাকে দিয়েছে?
গভর্নমেন্ট রেজিস্ট্রি অফিসে জমা দিয়েছিলেন।
He had deposited this money with the government registry office.
So when did you hand over the IGR to Mr. Rathi?
I guess a copy দিয়েছে।
ব্যাপারটা হচ্ছে উনি তো এসে তো নানা রকম পারিবারিক গন্ডগোল এর কথা বলতেন। তারপর বললেন যে দেখো তোমার নামে যদি না হয় থাকে
দাঁড়ান।
Firstly, he used to come to me and tell me about various family disputes. And thereafter, he told me that thereafter he told me that if this deed is not transferred in my name,
তাহলে কিছুই এগোনো যাবে না।
so nothing will proceed.
সুতরাং তুমি আমাকে দাও এটা।
So you hand over the IGR to
হ্যাঁ IGR
IGR to him. He asked me to hand over the IGR to him.
তারপর এসে বললেন যে গভর্নমেন্ট 36 কি 40-এর কাছাকাছি নাকি যাই হোক একটা টাকা পড়েছে
কি 1000 না
লাখ গিফট দিচ্ছে তোলার জন্য 35 থেকে 35 কি 40-এর কাছাকাছি।
এটা কি লাখ না হাজার?
লাখ।
That later on he again came and said that government has demanded 35 to 40 lakhs কিসের জন্য?
ওই গিফট ডিডটা তোলার জন্য।
For procuring the gift deed.
আচ্ছা
আর কিছু?
সেই জন্য তুমি আমাকে আইজিআরটা দাও, কারণ আইজিআরটা আমি নিয়ে তুলবো।
So he said to hand over the IGR to him and he will collect the IGR.
He will collect the deed. Opt-in.
They will obtain.
When was this?
কবে হয়েছিল?
এটা হয়েছিল তোমার এই 2017 সময় মনে হয়।
Sometime in the year 2007.
So in the year 2000, when the gift deed was executed, did you familiar? No, say it. So why did your father and thereafter you not make payment of the balance stamp duty? Why?
It's not stated anything about.
He has said, Acha, what did he say? Eta taka dein. Make payment.
I think
Acha,
he asked
why?
for the
I'll ask her,
36 to
I'll ask
40 lakhs.
So why did your father? Why did your father and thereafter you not make payment of the balance amount of the deficit amount? Deficit boleche. The deficit amount to the government to obtain the deed.
তো আপনি বা আপনার বাবা বা তারপরে আপনি কেন এই ডেফিনেটলি কম যে দেওয়া হচ্ছে ফ্যামিলি সেটা দেননি কেন শিক্ষা তোলার জন্য?
আমাদের কাছে পয়সা ছিল না।
We did not have money.
আমি তো বলিনি পয়সা ছিল না। ও যা বলেছে সেখান থেকে তুলি। ঠিক আছে। So during the time your father was alive, what was your involvement in your family estate and the management thereof?
Well, again, a leading question, Vinod.
বলুন তো, তো ভালো, এটা কি বলছেন?
What was your জিজ্ঞেস করেছি?
Request করে দাও, হয়ে যাবে।
What is your question?
I've asked that during his father, when his father was alive, what was his involvement in the family estate?
You can put a question when you involve when you're coming to. And
Yes.
then
হ্যাঁ, আর যখন আপনার বাবা
Allow করেছিল।
ছিলেন, তখন তাদের পারিবারিক সম্পর্কে আপনার কি করবেন?
বাবাই দেখতো, আমি দেখতাম না, কিছুই করতাম না।
My father used to maintain. I never used to.
My father used to maintain the property.
They got involved.
I never involved in the property.
I never.
I was never involved.
ঠিক আছে, তার next দিন করবো তাহলে।
Yes.
My lord. You have said that Mr. Rathi used to come and visit you at your Bangar house residence to hand over the rent. How often did he come?
তাকে বললেন যে বাঙ্গুর বাড়িতে আপনার বাড়ি টাকা দেওয়ার জন্য রেন্ট দেওয়ার জন্য পুরো কতদিন পর পর আসছে?
উনি প্রায় আসতেন প্রতি মাসে একবার দুবার। রেন্ট দেওয়া ছাড়া উনি আমাকে হোটেলে খাওয়াতেন, নিয়ে যেতেন, গিফট।
আপনার বাড়িতে He used to frequently come to my house apart from
Every month for rent, every month. আচ্ছা সেটা বলে দিন every month.
every month he used to come to hand over rent to me as well as casual visit he used to pay also. He used to also pay take me to hotel to
He used to take me to hotel for my food.
to for food.
হয়ে গেছে আপনার?
হোটেল ফ্রেন্ড
Why did he take you out to hotels?
Hotel
ওইখানে বসে উনি কথা টথা বলতেন, গিফট দিতেন, খাবার দাবার দিতেন। ওইখানেই আমি আইজিআরটা হ্যান্ড ওভার করি হোটেলের মধ্যে।
hotel
হোটেলের মধ্যে
he used to করতেন আগে
হোটেলে ওইখানে যেতেন, পারিবারিক গল্প করতেন।
we used to exchange greetings as well as
Discuss family matters.
discuss family matters. He used to give me gifts, offer me gifts.
আর আইজিআরটা ওখানে
I handed over the idea in the hotel itself. Idea to him in the hotel itself.
What kind of gifts did he offer you?
He gives
উনি জামা ভালো তো খাবার দিতেন, উইথ প্যাকেটও দিতেন বাড়িতে খাওয়ার জন্য।
he used to offer me clothes, shirts.
হ্যাঁ,
He used to treat me with good food. He used to pack
He used to give the packed food also.
food also for me,
হ্যাঁ, পেন
for me to take him back to home
আর পেন
and pain and other things also.
That's বলেছি।
That's বলেছে।
What is your case? What is your case?
You said Mr. Rathi used to discuss family matters with you. What kind of family matters did he discuss with you?
যেহেতু যেহেতু আমার বাবার থেকে অনেক আগে সম্পর্ক ছিল, আমি তখন ছোট তো বড় হয়েছে উনি তো, প্লাস পাছে যদি আমার ফ্যামিলি মেম্বাররা কি আমার কেউ যাতে এই পেটোরিয়া স্টেটের ব্যাপারে না আসে, যদি কোনো আলোচনা যদি না করতে পারি, তাই জন্য একটু থ্রেটনিং টাইপ অফ গল্প।
As he had good relationship with my father, and later on, since when I was a child, later on when I grew up, I see I had a relationship with him. He used to discuss matters with me so that other relatives does not get involved in the Pretoria Street property.
থ্রেটেন করতো যে মান্থলি, মানে ওপেনলি থ্রেটেন করতো যে অন্যান্য ফ্যামিলি, রাজেন্দ্র রাথি থ্রেটেন করে বলতো যে অন্যান্য মেম্বাররা যে ওর কাছে আসছে এবং যে কোনো সময় ওরা আমাকে নানা রকম বিপদে ফেলতে পারে।
Also threatened me that the other relatives are approaching him, and any moment I may face face danger.
Face difficulty
Difficulty
in relation to Pretoria Street property.
With regard to
Pretoria Street property.
উনি বলেছেন। Did you believe Mr. Rathi?
হ্যাঁ, বিশ্বাসই করতাম, কারণ ও ছাড়া তখন আমার কেউ বন্ধু ছিল না।
Yes, I used to believe it, as I had no other friend at the time. No friends other than him.
You have said that after your father's death, your relationship with the other members of the law family became better. How did it get better?
সেহেতু আমি আর বাবার সম্পর্কগুলোকে ঘাঁটিনি এবং সবই অফ করে দিয়েছিলাম আর সেই জন্য ভালো লেগেছে।
As I did not pursue the litigations which my father initiated against other family members, and I stopped pursuing all this litigation, my relationship with other family members became better.
Can you name some of these family members?
Some of these family
Can you name? Please name some of these family members.
সে তো অনেকেই আছে, এখন নামগুলো অত
There are
বলতে
many
পারবো না। সে বলতে পারে ডাক নাম হিসাবে সে
right now.
নামগুলো বলতে পারবো না, চিনি।
Now I cannot tell their name. I know their nicknames. Pet names also.
হ্যাঁ এবং চিনি, মুখে চিনি।
I know them by face.
I know the nicknames and I know them by
By
face.
face on identity.
When did your sister die?
2011-তে।
That's 2011. I don't know.
আচ্ছা সরি, এটা আছে আগে, প্রশ্নটা আছে আগে। আচ্ছা অন্য প্রশ্ন করছি, ওটা কেটে দিই, আগে বলেছি ওটা। আচ্ছা no, you have said that one of your sisters has expired. When did she die?
ওই তো
এক বোন মারা গেছে।
ওই 2011 সালে।
The year 2011.
So after your sister's death, who else is staying with you at Bangar Avenue flat?
আমি একাই থাকতাম, কেউ থাকতো।
I used to stay alone. No one else was there.
Do you mean to say someone else lives with you now?
এখন মানে আগে থাকতেন বলতে, তার মানে এখন
Someone else lives with you now?
না, এখন কেউ থাকে না, তবে পাড়ার বন্ধুদের সঙ্গে ঘরে বসে গল্প করি অনেক রাত পর্যন্ত।
now also no one stays with me, but my neighborhood friends comes to me and we have a chat session with them late till late night.
What kind of discussions do you have with your neighborhood friends?
পাড়ার বন্ধুদের সাথে কি ডিসকাশন হয়, কি আলোচনা হয়?
এমনি পাড়ার গল্পই হয়, তা প্লাস একটা পূজা কমিটির সদস্য আছি, পুজো কমিটি নিয়েও আলোচনা হয়।
General discussions we have. We also discuss about as we are members of a certain puja committee of our locality. Discussions also are held regarding the pujas and all.
while your father was alive. Uh, you have said that you were not involved in the family estate. Sorry, question take it. Sorry. What was your relationship with your father while he was alive?
আচ্ছা বাবা ছেলের যেমন সম্পর্ক ভালো থাকে সেরকম থাকতো।
A normal relationship with
My father as son and father and son.
Like a father and
like
son.
a father and between a father and
Yes. Next.
Very well done. Mm. What did your father tell you in relation to this 6 Pretoria Street property?
বলেছিল যে প্রপার্টিটা বড়, বড়,
he said that the property is
হ্যাঁ
big.
আমি তোমাকে দিচ্ছি, তুমি সই করেছো, ওই দিচ্ছে মানে gift। আমি বাবার আমি তো সই করে তো এটা তো যায় তো।
বলছে বলুন।
হ্যাঁ
He said that he is giving this property to me and I have signed in the document.
হ্যাঁ তুমি এত বড় প্রপার্টিটা বেচো না, মেনটেনেন্স করো।
He asked me not to sell the property and maintain the property.
Maintain
Maintain the
and rent the property.
রেন্ট রেন্ট
Maintain, rent.
রেন্ট
Maintain বলেনি, rent.
রেন্ট আর মেনটেন একসঙ্গে তো।
Maintain and rent the property.
maintain and rent the let out the property.
Maintain and let out the property. Yes, sir. আচ্ছা কি বললো একবার বলুন আনসারটা।
Huge one. Huge one.
Maintain and rent out. What documents did you sign?
বাবা যেটা গিফটটা করেছিল তলায় সাইন করতে হয়েছিল,
He
Well,
did it.
গিফটের তলায় নাকি সাইন করতে হয়, সাইন করেছে।
As I have to sign at the bottom of the gift, I had to put my signature.
Who asked you to sign?
রেজিস্ট্রারই বলেছিল সামনে যে তুমি সই করো।
Sir had asked me to put my signature and I had signed.
So why did your father ask you not to sell the property?
আপনার বাবা কেন বলেছিলেন যে বিক্রি না করতে পারবেন?
পূর্বপুরুষের সম্পত্তি প্লাস ওখান থেকে আয় করো, বিক্রি করো না।
As it was an ancestral property.
I supposed to tell.
আচ্ছা ঠিক আছে, কেটে দিন কোয়েশ্চেনটা। So did you follow your father's wish and not sell the property?
কি ওনার কথা রেখেছিলেন এবং
হ্যাঁ।
বিক্রি করেননি?
হ্যাঁ,
Yes, I have. You have said that Mr. Rathi, that you gave the IGR to Mr. Rathi. You gave the IGR to Mr. Rathi in the year 2017. And he indicated to you that rupees 35 to 40 lakhs is payable to the government. Did you make such payment?
এবং মিস্টার রাখি বলেছিলেন যে 25 থেকে 30 লক্ষ টাকা লাগবে। এই টাকাটা কি দিয়েছিলেন?
He said 2017. No, he said.
Earlier,
I asked him when. He said 2017.
sitting in the hotel.
Yes. বলেছে 2017, দেখুন একটা প্রশ্ন আছে। I had asked when, he said 2017.
No, she has not taken, the other person has taken.
এবারে আমার সঙ্গে কথা হয়েছিল, আমি বললাম যে কিছুটা একটু বেশি ওই টাকাটা যেহেতু যেটা উনি দেওয়ার কথা আছে, ওই ওই রাজেন্দ্র কুমারতির সঙ্গে কথা হয়েছিল, যখন আইজিআর দেয়া হয়েছিল, কথা হয়েছিল যে উনি আমাকে মোটা টাকাই দেবেন, হ্যাঁ, টাকাই দেবেন এই ব্যাপারে।
At the time when I had handed over the idea to Mr. Rathi, I had a talk with him that he will give me a hefty sum. Hefty. মোটা টাকা, hefty sum.
হ্যাঁ, যে মোটা টাকাই দেবেন, কিন্তু এখন বর্তমানে যেটা তিনি দিচ্ছেন রেজিস্ট্রি অফিসে, সেটার সঙ্গে কিছু টাকা দিলে আমি একটা ফ্ল্যাটের খোঁজ নিতে পারি।
আরেকবার বলুন।
তিনি যে টাকাটা দিচ্ছেন, যেহেতু গভর্নমেন্টের ঘরে তো দিতে হবে, এটা গভর্নমেন্টের ঘরে যারা দিচ্ছেন, কিন্তু তার সঙ্গে এক্সট্রা কিছু টাকা দিলে আমি একটু ভালো জায়গায় থাকার চেষ্টা করতে। হ্যাঁ,
he said that depositing the money, it is the government, as well as he will hand over some more money to me so that I can reside in a better place. In a better place. একটু ভালো জায়গা থাকতে হবে।
হ্যাঁ, তারপর হিসেব করে 35-এর মতো হয়েছিল, হয়ে আমি বললাম দেখুন 35 লাখ 35-এর মতো গভর্নমেন্ট নেবে।
After calculation, it came out that 35 lakh rupees.
Around 35.
Around 35 lakh rupees. What is the deposit with the government?
আর তার বদলে উনি কিছু টাকা দিয়েছেন, উইদিন
তার বদলে
মানে এক্সট্রা দিয়েছেন তার বদলে। হ্যাঁ,
he paid me some extra money.
নিয়ারলি 16 লাখ টাকা
About 16 lakh.
ফর ফ্ল্যাট দেখার জন্য।
For me to get a flat.
হ্যাঁ, এবং যখন ডিটেলস যেটা এখন শুরু হয়েছে যে কেসটা, যখন ডিটেলস শুরু হবে উনি এই টাকাটা মাইনাস করে নেবেন।
And after this, sir, একবার বলুন এই যে কেসটা
না মানে এখন যে কেসটা শুরু হয়েছে যেটা নিয়ে শুরু হয়েছে করেছি আমি
Suits that I have
case
filed.
which is going on, the instant case which is going on, এটা
হ্যাঁ সেই মানে সেটা আগে যখন টেস্ট করিনি, এটা যখন শুরু হয়েছিল, শুরু হওয়ার সময় ছিল তখন বলেছিল যখন এই এই জিনিস এই এই কেসটার যখন মানে যেটা অরিজিনাল যে কাগজপত্র যখন হয়েছিল, বলেছিল আমি যখন কাজ করব তখন ওই
কে কাজ করবে কি কাজ
ওই
করবে?
রাজেন্দ্র কুমার বাকি যখন কাজ করবে ওই টাকাটা কেটে বাকি টাকাটা
কি কাজ করবে?
এই এই লিস্টটা
all official work.
And the Mr. Rajendra Kumar Rakhi told me that when he will start working in this case, he will adjust the money.
Which case are you referring to?
কোন
এই
case
যে
এর
এই যে
কথা
এই যে একটা কেস যেখানে তিনি 7 কোটি টাকা দেওয়ার কথা ছিল, দেননি উনি। হ্যাঁ,
বলছেন? 7 কোটি টাকা
উনি আমাকে দেবেন বলেছিলেন।
the case for which the case for the no, no, he was to give me rupees 7 crore and which he has not given for regarding that.
হ্যাঁ, রিগার্ডিং দ্যাট যে এই এই লিস্ট প্রপার্টি যেটা হচ্ছে, যেটা তৈরি হচ্ছে, যেটা আমি এটা প্রেস লিস্ট করেছি। হ্যাঁ,
Lease, lease.
হ্যাঁ, হ্যাঁ,
Lease এর
প্রেস
কথা।
লিস্ট করেছি আমি
ও
কিন্তু।
কেস মানে লিজ বলছে বোধহয়।
হ্যাঁ
না কেস
তাহলে ঠিক আছে, দুটোই লিখে।
হ্যাঁ, এই এই লিস্টটা থেকে পরে তো কেস হয়েছে, তো লিস্টটা যখন করেছি তার আগে উনি
This, the case was initiated.
পুরো দেখুন, যেটা বলতে দেখুন না, আপনি রিপিট করুন একবার প্রশ্নটা
থাকবে।
করুন। Which case are you referring to?
কোন কেসের কথা
হ্যাঁ,
বলছেন আপনি?
উনি ব্যাপারটা হচ্ছে উনি আমাকে পরিষ্কার করে আগে বলি 2011 সালে নভেম্বর এই সেপ্টেম্বর নাগাদ একটা প্রেস লিস্ট করান।
He entered into a he entered into a press release with me into a press release with me in the year 2011 December.
না সেপ্টেম্বর।
September.
হ্যাঁ, রিগার্ডিং 6A পিটোরিয়া স্ট্রিট।
Regarding 68 Road.
হ্যাঁ, 6A পিটোরিয়া স্ট্রিট করেন, তাতে কথা হয়েছিল 7 কোটি টাকা তুমি আমায় দেবে, উনি দেবেন।
It was told to me that he will give me
he will pay rupees 7 crore.
rupees 7 crore.
হ্যাঁ, তাছাড়া তুমি এবং ওই ওই 7 কোটি থেকে আমি 50 লাখ টাকা কেটে নেব।
And he will deduct 50 lakhs from that 77 crore.
হ্যাঁ, বলুন।
That's all. Stop here.
The corrections?
আমি দেখে দেবো, আমি দেখে we'll incorporate.
Well, I have handed over the correction.
I'll have a look at it, Milord, and we'll do it.
For the number 2 and 3. Plaintiff witness examination in chief of the plaintiff witness number 1 resumed today, and during his evidence, one document is marked as exhibit A within bracket with objection. Due to paucity of time, examination chief would not be completed. Examination chief of the plaintiff witness number 1 is deferred. Let the matter appear on 29 January.
Milord, next date?
29 January.
The witness is his box, Milord. He can conclude.
I'm not before reopening one day. Half an hour.
All his prayers are
I don't think he will complete further 2 days. The witness,
is it taking very a long time?
the way the witness is going,
I can't.
he has not is still entered into the plane.
No, only one submission. Only
I'm in paragraph
first week of
13 of the plaint right now.
first week of January. No, only one week.
No, but time and date is there. Any time is there. This because all the cases are fixed. That is the problem. 3 p.m. 3 p.m.
Started for me also. Has your lordship read the plaint, my lord?
Huh?
May it please, my lord, I was showing my lord the award
Yes.
in the petition.
Correct.
What did the arbitrator say about the nature of the agreement? Then registration stamp acceptable.
Other side is there. Other side has come.
Yes, yeah. At page 27, the award begins.
Yes.
Then page 28. This is the plaintiff's, the claimant's case. The arbitrators were very shocked at the drafting of the agreement. It's completely one-sided towards me, though it's their document. So they even said the contra preferentum, it will be decided against them, even if it seems this thing. The claim and controversy arises from an abysmally drafted document being agreement dated 31st December, made between the claimant and respondent. The respondent contends that the agreement is an investment agreement, which provides that in consideration of the investment of a substantial sum towards eventual purchase of the designated area to be constructed, the respondent, pursuant to a collaboration agreement with HITCO, the respondent would be obliged to pay interest on the sum invested by the claimant. So that is my contention. What was the agreement? Then the arbitrator says, it is of utmost importance to examine the true nature of the agreement first, to appreciate the real controversy and its resolution. Despite the claimant's assertion that it is an out-and-out investment agreement, there is no such nomenclature used in any part of the agreement. The terms and tenure of the agreement, and to the extent the shadow of collaboration agreement, that is the agreement between the respondent and the original owners, make it abundantly clear that the complex, elaborate arrangement of investment were steps towards the final transaction. I'm not disputing that. We are going to buy it, but right now it's an investment. You're building it, it's going to take time. You pay me my investment. And that is the scope of the arbitration. Then, this is very important. However, there is no denying the fact that the prime motive of the claimant in entering into the agreement was investment prospect, and on the understanding the respondent had accepted the offer of the claimant. This is clearly recorded in recital D. I placed that recital. Then paragraph 4. The project under collaboration agreement was apparently a long drawn, time consuming affair. And on that understanding, the parties clearly felt that a formal agreement for sale would be entered into in good time at a future date, to be followed by a conveyance. These interpretations made by the arbitrators are within their scope, and they have considered the nature. It's not that they have ignored this point which they have taken of perversity. The simple argument was, we made an application, they didn't decide that application. Then the claimant apparently was not interested to enjoy the building for its beneficial or individual use or requirement, but as investment by way of return of money paid. And to this end, it was provided in the agreement that the purchase price would be advanced in separate tranches from time to time at varying but specified rates of interest. Again, the same intention, it was provided that at the appropriate stage, the respondent would procure, that they would procure the tenants to ensure a return on its advance calculated on the basis of clause 7. This is at 13%. Now, paragraph 34, I've also already placed what they said about the stamp and etc. Then the award itself is a money award. So what I'm trying to say is, besides the nature of the agreement, what was the nature of my claim? I have not asked for specific performance of a agreement of sale. All the judgments my learned friend shows are to do with an agreement for sale. I have not touched the money that I've paid towards the grander scheme of things. Maybe the agreement it is moving towards an agreement to purchase the property. But the dispute that arose is you are not paying me the assured amount and the interest. So I went for arbitration. So whether such a document requires stamping at all, well, then now your lordship has seen the document and seen what the arbitrator has held. Now, my lord, if my lord sees the act, Stamp Act. First the Stamp Act, then the Registration Act. Well, before that, well, one thing I should point out that in both the parties, written notes of arguments are submitted. In my written notes of submissions, page 553 of volume 4. It was specifically argued why my learned friend submitted the award is silent, etc. 553.
Yes.
Interest in immovable property. This is the notes by the claimant. Paragraph 12, 553. So your lordship will see this is still my argument. I'm placing it 12. Since no right, title or interest in the immovable property has been or is to be transferred to the claimant under the agreement of 31st December, there is no need for an agreement for the agreement to be registered or stamped. The document does not come within the purview of 17 or 49 of the Registration Act. Now, their only argument in the arbitration was my witness. They asked, "Do you think this creates a interest in property?" I objected immediately because it's a question of law. Now the witness said, "Yes, I think I'm going to get the property eventually." So the witness had said yes in questions 92 and 93. Those are at page, I'll show that. But those questions have gone down subject to objection. And here I have given my objection again, merely because the witness answered the legal question that it had an interest in created in the property in favor of the claimant does not make it so. The typed deposition would show that counsel for the claimant objected to the legal opinion sought by virtue of question 93. It has been recorded that the question is subject to objection. In the circumstances, the demurrer application is liable to be dismissed, since the application is a pure point of law on the basis of an admitted document. No affidavit, this is wrong, affidavit directions were given. But my lord, we had taken the maintainability of that application. And your lordship has seen prima facie, on the face of it, it is made after their defense, after my evidence.
Affidavit is fine.
Then similarly, paragraph 14 at 554, why it is not registrable. Now, this point, if I may just tell my lord, registration is not the SMST and NN Global. They make it very clear that even if it's not registered, arbitration agreement is considered a separate agreement. Why it is not for stamped, I still haven't understood, but maybe 7th judges bench. Because the way I look at it, my lord,
that is the creation of problem.
the arbitration agreement is like the black box. It survives the crash. For whatever reason the plane crashes, it is a separate agreement. And they've written that in Justice Ravindran in SMST, distinguished it that way, that the arbitration agreement need not be registered. So it's a separate agreement. But for Stamp Act, it does not have to be stamped. An arbitration agreement need not be stamped. But if the whole document is inadmissible for stamping purposes, then the arbitration is hit. So this, maybe it will be clarified or not, but it is really making parties get revenue for the government. So earlier, I'm told in the High Court, these stamp points were never taken.
Never.
Because it was, we are not here to be tax collectors. But now with the Supreme Court judgments, obviously it's got a huge importance.
The agreement for the contract for the safer side of the party.
Yes.
Why?
So now, so this and my lord, their contentions, page 6 at 642, if my lord comes, yeah. It begins there. Written notes of submissions begins at 635. They have given in bits and pieces in each claim they have given. But 643, your lordship will see, they have taken this point. All things made clear, 643, the first paragraph. I'll just start at 642, my lord, because they say the last part of 642, this is their argument. Clause 12 itself gives the right of the claimant to dispose of the said premises. The respondent in such a situation has the right to first make an offer.
Where
to,
from you are reading?
I'm sorry, 642,
Mm-hmm.
the last
last
paragraph.
Got it.
Because this clause
Yes,
12
yes, yes.
I've dealt with, but it's there. Clause 12 itself gives a right to the claimant to dispose of the premises. The respondent in such a situation has the right to make an offer of purchase at the same prevailing market rate. Moreover, according to CW2, no other document was required to be executed to enable the claimant to obtain possession. And on the basis of the said agreement, a right was created in respect of the property. This is what the respondent said. But he doesn't record here, which is in my note, that these two questions went down subject to objection. Then, as such, the document does not merely create a right to obtain another document, which will, when executed and created,
Interest in the
declare a right, title, and interest in the property. Such right is conferred by this document itself. All this makes clear that the document itself results in a creation or declaration of a right, title, interest, and of a immovable property within the meaning of section 17. And then by virtue of 49, it cannot affect. Right. Then they themselves have acknowledged that this is not a suit for specific performance. And he says that you cannot look into the document for any other purpose as well. The claimant relies solely on the document for its claim. Without the document being stamped and registered, the claim cannot be permitted to do so. This is his argument. He had put it in his notes. He had argued it before the arbitrator, put it in his notes. Paragraph 34 of the award clearly deals with this. Now I'll show the stamp act. Well, my learned friend points out, when I read out my notes, paragraph 12 to 15 to 19, the entire chapters.
Yes, sir.
I've dealt with that specifically. Same thing that I'm saying now, man. Now, section 2.4 was shown by my learned friend. Section 2. What to name? No. What to name? Article 5, if my lord comes.
Yes, article.
Article 5.
Yes.
5D. If agreement or memorandum, if relating to sale or lease cum sale of immovable property, then the duty is to be payable.
5D.
Article, not section.
Article.
The West Bengal direction.
Showing the West Bengal or Indian Stamp Act?
No, the Stamp Act. The section 36. Yes, Manoj, the article in the schedule 1. Manoj,
Yes,
here's the book. It's the same thing. It just says immovable property, if it's for lease or agreement for sale, it has to be stamped. But I am saying that this agreement is not. So that is the first. Now, if my lord comes to section 35 and 36 of the Stamp Act, Indian Stamp Act. There's so many acts in this book. So my learned friend is saying under 35, it is inadmissible in evidence.
35 of?
The Indian Stamp Act, 1899.
Yes. Yes.
So no instrument chargeable with duty shall be admitted in evidence for any purpose or by any person having by law or consent of the parties authority to receive evidence, or shall be acted upon, registered or unauthenticated by any person or by a public officer unless the instrument is duly stamped. This is the objection they took. Now, my lord will read 36. Where an instrument has been admitted in evidence, such admission shall not, except as provided in section 61. I'll come to that. Section 36. It's the next.
Yes.
When I'm reading the section, where an instrument has been admitted in evidence, such admission shall not, except as provided in section 61, be called in question at any stage of the same suit or proceeding on the ground that the instrument has not been duly stamped. Now 61, if my lord comes, before I leave the act. 61 says when the court can do so. 61.
Yes.
Revision of certain decisions of courts regarding sufficiency of stamps. When any court in exercise of its civil or revenue jurisdiction or criminal court in proceedings, etc., makes an order admitting any instrument in evidence as duly stamped or not, requiring a stamp, or upon payment of duty and a penalty under 35, the court to which appeals lie from or references are to be made, such a first mentioned court may, of its own motion or application of the collector, take such order into consideration. So in the appeal court, the court has the power, or now section 34 is not an appeal. That has been said 100 times.
That is not okay.
So that is the thing. So now I'll deal with the decisions.
What is
I have
34?
shown, my lord, that it was admitted.
What is 34? What is 34?
It is for challenging the procedure of the.
It is a summary procedure.
Yes.
Yes.
So, my lord, I have shown, my lord, where it was exhibited, there was no objection. The objection came much later. They argued it. Arbitrators have considered it. I think I've covered most of the points. Now, my lord, the decisions of my learned friends. First is 2014, 1 SCC 618. Om Prakash versus Lakshmi Narayan. The 4 decisions my learned friend has shown. And 1 today. When we will come to the 3rd page, the paragraph 1.
Which one, Om Prakash?
Om Prakash versus Lakshmi Narayan. I'm simply distinguishing on the first line itself. The plaintiffs filed a suit for specific performance of a contract, possession and permanent injunction in respect of an unirrigated land. So how this, my learned friend said this document for in respect of an unirrigated land was an agreement to sell. It is founded on an agreement to sell dated 27th December 2020. Then paragraph 2, the agreement is set out that while selling the aforesaid land, I have received. So there was no dispute that was the agreement for sale. So then paragraph 4, the submission made by the defendant found favor of the trial court and held that the agreement to sell to be inadmissible in evidence as it was not stamped, as it has not been sufficiently stamped.
Where from you doing?
Paragraph 4. This is just what the dispute was. It was an agreement for sale. he took this point. And then he succeed. Then the definitions are given. What is a conveyance? Says an agreement for sale is as good as a conveyance. My paragraph 13.
Yes.
One of the relevant part by my learned friend showed was paragraph 16. So paragraph 16, from a plain reading of the aforesaid provision, it is evident that the authority to receive the evidence shall not admit an instrument unless it is duly stamped. An instrument not duly stamped shall be admitted in evidence on payment of the duty which is with which the same is chargeable. And in case of an instrument insufficiently stamped, the amount required to make up the duty with the penalty. As we have observed earlier, the deed of agreement not having been sufficiently stamped, and the same was inadmissible as an evidence, the court being the authority to receive the document in evidence, etc., the agreement to sell with possession is an instrument which requires payment of stamp applicable to the deed of conveyance. Then, my lord, another view was taken in this judgment Avinash, which is paragraph 17, but it was
not considered.
It was overruled, I think, in the paragraph 18. To put the record straight, the correctness of the impugned judgment of Lakshmi Narayan Om Prakash, I think that's the opposite, came up for consideration. That's the came up for consideration before the division bench in this writ petition, and the same was overruled. When that paragraph 8 and 9 they showed, a document would be admissible on the basis of the recitals made in the document. Now, our recitals say it's an investment agreement and not on the basis of pleadings. In the matter of Lakshmi Narayan, the learned judge, with due respect to the authority, did not look into the legal position, but it appears he was simply swayed by the argument of the defendant, was not denying the delivery of possession. The endorsement in the document lost all its efficacy. It would be tried to say that if in a document certain recitals are made, the court would decide the admissibility of the document on the strength of the recitals and not otherwise. In the given case, there was an absolute unregistered sale deed, and the parties say that the same is not required to be registered. Then we do not think the court would be entitled to admit the document simply because simply the parties say so. So, Your Lordship, the authority in question has to look into the document. And in our case, the arbitrators have studied the third paragraph of the award says we have to first see the nature of the agreement. So,
yes.
And paragraph 34, it clearly says that it is not required to be registered or this. Now, 1969, 1 SCC 497. My learned friend had shown at page 499, the last paragraph. But here it's a mortgage deed. I don't have to say anything further. It was a deed of mortgage which affected immovable property. You also will see the last paragraph of 499. As we have already said, Exhibit A26 was required to be registered under Section 54 of the Transfer of Property Act. In the absence of such registration, the document cannot be received in evidence of any transaction affecting the property in view of Section 49. It is, however, urged on behalf of the appellants that the effect of Section 4 was not to make Section 49 applicable to documents which are compulsorily registrable under provisions of 54. And in support, they had cited this case. I need not go into this. The facts were completely different. I have not said that this was a registrable document, and we have clearly argued and demonstrated that no right was created. Simply, even that line that went in the earlier judgment, simply because our witness said, yes, after I can show that cross-examination trend, it was as if like you have no right under this agreement. So he said, yes, I think it does I do have a right in that agreement. So this decision also doesn't apply on the facts because this is to do with, and this is to do with only registration. Lack of registration does not make an arbitration agreement annulled. Then 1989 for SCC, page 39, paragraph 7 was shown to my lord. It begins with the first paragraph itself. Well, paragraph 2 I'm showing, page 41. The respondent owner of the premises let it out to the appellant in 61 as a monthly tenant. An unregistered deed of lease was executed. So this was a deed of lease, which is under 107 also, it's of the Transfer of Property Act. It is to be registered if it is more than a year. Paragraph 7 was relied on. The contention of the learned counsel for the respondent that the aforesaid clause cannot be looked into for want of registration of the lease deed appears to be correct. Reliance was placed on such and such that if a decree purporting to create a lease is inadmissible in evidence for want of registration, none of the terms of the lease can be admitted in evidence, and that to use a document for the purpose of proving an important clause in the lease is not using it for a collateral purpose. So I am not saying that I am using this document as a collateral purpose. I'm saying this document itself does not create a right in immovable property. Yes. Then, so this also, my lord, it's to do with, it's saying that even if you're not relying on it as a lease, you can't look into a provision to show that. Then the last case, my lord, that he cited, 2008, 8 SCC, page 564, paragraph 34. Again, this was a mandatorily registrable lease. Paragraph 34.
Yes.
So these are principles of law, my lord, which will be applicable if the facts.
If it is a registerable document, it cannot be taken into.
A document required to be registered, if not registered, is inadmissible as evidence. Such unregistered document can, however, be used as evidence for collateral purpose. Then it explains what a collateral transaction is. So this also, my lord, strictly not applicable. Now the last thing my learned friend showed was NN Global, 2023, 7 SCC, page 1. It has a printout. No, Bhaskar Raju.
This is today only.
This has been referred to a larger bench, but my learned friend has not relied on anything. But I think what he says is that if it is unstamped, the whole document cannot be looked into, and therefore the arbitration clause is inadmissible. That is his contention. It's relying on SMST. Now, SMST, if I may show, my lord, though the dissenting two judgments have overruled it, but it was upheld by the majority in so far. So SMST, my lord, the portion I wanted to show, my lord, as a matter of (2.6). Yes, 22.6. 22.6 at page 75. Where a document is compulsorily registrable but is not registered, but the arbitration agreement is valid and separable. What is required to be borne in mind is the arbitrator appointed in such a matter cannot rely upon the unregistered instrument except for two purposes, that is, as evidence of a contract in claim of specific performance, as evidence of any collateral transaction which does not require registration. So that you can't look into the document, but the arbitration agreement remains valid and separable. Now, the rest of that, which is really an issue now, is whether if it was unstamped, whether the arbitration could have proceeded. Section 36 is a complete answer to that. More than that, now one Delhi decision I want to cite, it covers all, it's a very recent decision, also considers NN Global. I'll just show that one. 2023 SCC Online Delhi 3885 ARG Outlier Media versus HT Media. Now I have marks. So if my lord comes, first is, this was my learned friend has not shown any section 34 petition except NN Global to some extent. Now this was a section 34 application. So the petition has been filed under section 34. Now my lord will come to 3A to show which is the issue that I'm deciding. The petitioner challenges the impugned order on 3 grounds. A is the important. That the agreement containing the arbitration clause, being improperly stamped, should have been impounded by the learned arbitrator, and until it was properly stamped and penalty was paid as determined by the collector of stamps, should not have been acted upon. So this is a similar point that was taken. Now, paragraph 6, the issue, the other 2 claims was whether their compensation was in terms of the agreement or not. I'll come to, that's not important. Then my lord will come to paragraph 6, where the issue has been summarized. What was the petitioner's submission? 6. They submit that the learned sole arbitrator has also wrongly stated that no submission on the issue was made at the stage of final argument. Relying upon the written submissions before the learned arbitrator, they submit that this issue was raised before the sole arbitrator, even at the stage of final argument. In this case, a section 16 application had been made. The arbitrator rejected it. So there is already an order rejecting it. But the arbitrator said you are at liberty to argue it further. They did not argue it. But so they are saying that he did not address this issue in the final. In our case, it has been addressed. Then, my lord, paragraphs 11 to 13, these are the submissions made by the respondent, and it is also in line with what I am saying. So I'm just showing this quickly just to say what submissions he made. So paragraph 11, he further submits that during the course of oral submissions, did not raise this issue again, as has been rightly recorded by the learned arbitrator. In our case, it was raised with the least amount of gravity. That's how the arbitrators put it, least amount of gravity. Then he submits that a mere clandestine insertion of the ground in the written submissions now cannot be used as a ground of challenge. Then 12. Yes, 12. He further submits that, in fact, no such objection was taken by the petitioner prior to filing the application under section 16. In the exchange of notices between the parties, the several dates, or even in the answer to the petition under section 11. On all 3 counts, my lord, it's same as us. Initially, they had not taken it. In the section 11, they have not taken it. And the petitioner never raised the plea of argument, was executed in Mumbai. So in this case, what had happened was the petitioner in the section 34 contended that the agreement was last signed by the respondent in Mumbai, and the Mumbai Stamp Act should apply. Under the Delhi Stamp Act, it was fine, the thing. So that point was ultimately rejected, and it was held that it was done in Delhi itself. And then paragraph 13, I had marked my. Then paragraph 13, on the interpretation of the agreement, placing reliance on various terms of the agreement, he submits that the interpretation placed by the sole arbitrator on the terms of the agreement is correct, and he submits that it was the term of the agreement that the inventory, this is on the second issue. So here also, it was not, yeah. Okay. So those were the submissions of the respondent. Now, one of the findings are from paragraph 19. Yes. Paragraph 17 and 18 deals with their section 16 application. So I'm skipping that. That was the order. Now, paragraph 19 is at page 8.
Yes.
At the outset, it is to be emphasized that the above finding is a mixed question of fact and law. This is in section 16, where the Mumbai or Delhi Act applies. The learned sole arbitrator has found the agreement to be properly stamped observing that under the agreement it was agreed that the same had been executed in New Delhi. Everything under the agreement has to happen in New Delhi, and the document was signed in New Delhi by one of the parties. Then, it is settled law that the court exercising jurisdiction under Section 34 of the Act does not sit as a court of appeal against the findings of the tribunal. Its jurisdiction under Section 34 is rather limited, and even a contravention of a statute that is not linked to public policy or public interest cannot be a ground for setting aside the award under Section 34. Then Sang-Yong is quoted. This is now the leading judgment. 2019, 15 SCC 31. So it says, paragraph 37, second sentence, here there must be a patent illegality appearing on the face of the award, which refers to such illegality, goes to the root of the matter, but does not amount to a mere erroneous application of law. In short, what is not subsumed within the fundamental policy of Indian law, namely the contravention of a statute not linked to public policy or public interest, cannot be brought in by the back door when it comes to setting aside the award on the ground of illegality, patent illegality. Secondly, it is made clear that the reappreciation of evidence, which is what the appellate court is permitted to do, cannot be permitted under the ground of patent illegality. So the evidence he has taken into account, it's a mixed question of law and fact, whether this document was registered or not. But really Section 36, it will come, my lord, in this judgment itself, is a complete answer in any case. So my lord, Sang-Yong is dealt with in paragraph 19. Then paragraphs 21 to 22, it just sums up that no earlier objections were taken. And they can't take this point now. 21 and 22. Therefore, even assuming the learned arbitrator made a mistake in the interpretation of the Maharashtra Stamp Act, in my view, it cannot be a ground to interfere with the award in the exercise of the limited jurisdiction under 34. What is relevant in the facts of the present case is that no such challenge on the ground of the agreement not being properly stamped was raised by the petitioner in its reply to the legal notice, as in our case, or in reply to the petition under Section 11, even in our case. Even in the affidavit of admission and denial of documents filed by the parties herein, the agreement was admitted. In our case, they have annexed it to this counter statement. They have made a counterclaim. The council at the first day has said it is not disputed. I've shown all those pages, Manoj. And at the time of tendering, no dispute. He disputed other documents. I had to prove by oral evidence. But he did not dispute this agreement. The agreement was admitted and no such objection as to the admissibility in evidence was taken by the petitioner. Then Manoj, a series of decisions under Section 36, which I showed, Manoj, of the Stamp Act, is from paragraphs 27 onwards. And I'll just place this. I placed the sections, but I'm just placing 27. Section 36 of the Stamp Act states that where an instrument has been admitted in evidence, such admission shall not, except provided under 61, be called into question at any stage of the same suit or proceeding on the ground that the instrument is not stamped. Section 61 provides that where any court in exercise of civil, well, the rest are not important, makes an order admitting any instrument as a duly stamped, the court to which appeal lies from or reference is made by, this is important. Such court on its own motion or the collector or on the application of the collector may take such order into consideration. Otherwise, no one else can. In our case, the court is of the opinion that such an instrument should not have been admitted in evidence without payment of duty and penalty under 35. It may record a declaration to the effect that determine the amount of such instrument is chargeable and may impound the same. Then impound the same under Section 61. Further, Section 61 further provides that except for the purpose of such prosecution by the collector, any declaration made under 61 shall not affect the validity of any order admitting the instrument in evidence. Then sections 36 and 61 are set out. Then, my lord, the decisions, which starting from 1962, I'll just read out the citations, my lord, because the first one on 36 was 1962 2 SCR.
Yes.
It relies on section 36 that once it's admitted, it cannot be called into question in that suit, at any stage of that suit. As far as the parties are concerned, the matter is closed. Then 31. Then there's a more recent Supreme Court decision. We have got this separately also. 2006 11 SCC 331. The above proposition has been specifically applied to reject the challenge to an arbitral award on account of the document not being properly stamped in such and such Calcutta Weekly Notes, and it sets it out. In any event, it seems clear to me the submission in the case was a document which had to be put in evidence before the arbitrators. It was their duty to see it was properly stamped. It was not stamped. If an objection had been taken at the time, then the proviso to section 34(5) would have come into force, and upon payment of the stamp duty and penalty, the document would have been admitted in evidence. That was not done. It is necessary, therefore, to refer to another section, section 36. Then the section 36 is set out, and it says, section 61 was not material. Then the submission was, in my judgment, admitted evidence by the arbitrators, and having been admitted in evidence by the arbitrator, it was not open to either party to call in question such admission in the arbitration proceedings on the ground that the submission had not duly been stamped. The award, therefore, which was made on such submission was, in my judgment, a valid award. Then, if my lord comes to the last few underlined lines, it is to be remembered that the provisions of the Stamp Act, which were passed for the purpose of protecting revenue, and in my judgment, the words which have been relied upon by the Advocate General of Section 35, under the circumstances of the case and having regard to the Section 35 and 36, have no effect, rendering the award invalid. But this 2006 decision is on the point, Supreme Court. It does not set aside the award. I'll give it separately, Manoj. I haven't finished with this decision. I'll give it after this, since it's then coordinate bench, another Delhi High Court bench, Manoj. Again, it says this point cannot be taken. Now, paragraph 32. Section 36 clearly prohibits calling into question the admission of any document in a suit or proceeding once the document has been admitted on evidence on the ground that it was not duly stamped. In arbitral proceedings, it is well settled that the strict rules of CPC would not apply, and the learned arbitral tribunal entitled to chalk out its own procedure. In doing so, the governing consideration would be expeditious resolution of the disputes without subjecting the arbitration to lengthy, cumbersome rigors of procedure. Once the parties agree to the procedure formulated, the parties are bound. So by affidavit evidence, when I gave the evidence, they had a right to object. He objected to many documents. I had to prove them. So that procedure. The court sitting in judicial review over the decision of the tribunal cannot therefore ordinarily interfere on the ground that it does not follow the strict procedure of CPC. Even otherwise, I have already noted that the rigors of CPC and Evidence Act will not apply to the arbitral proceedings. And then, that being so, if the arbitral tribunal took the view that the petitioner, having admitted the copy of the agreement for sale, so in that case it was a much higher case, has been filed before the respondent at the stage of admission and denial of documents without reservation, could not be allowed to raise on the ground of insufficient stamping at a later stage. That view does not call for interference. But in Calcutta, we still go for the oral evidence in arbitration. So at the time of exhibiting, you can object. But most of the arbitrations I'm seeing, they are just saying on the documents itself. So this whole process is shortcut. So if I was on the other side, sometimes you lose out that opportunity. You have to be aware that once you agree to the procedure, you must be able to object at your first chance. Because it's given by affidavit. and then maybe someone overlooks it, etc. Then one last bit is there. How he distinguishes, how he says that NN Global doesn't apply to these facts because there the agreement was not on the facts of it given. That's paragraph 36. Before concluding this issue, it must be emphasized that though in terms of the judgment of the Supreme Court in NN Global, this is the 23 judgment, the agreement not being properly stamped could not have been admitted in evidence. However, once having been admitted in evidence by the arbitrator, the award passed relying thereon cannot be faulted on this ground. This court does not act as a court of appeal against the award, and therefore may not even have the powers vested under section 61. Even assuming 61 applies, in view of the proviso B to the section 61, the court would only impound the document in the present case by calling on the petitioner to produce the original and refer it to the collector of stamps for adjudication of proper duty. In the present case, paid. However, the same shall not in any manner affect the enforcement or the validity of the award. Even today, if my lord feels, no, you're cheating the revenue, I'm impounding this document. He will have to produce the document, the original. It will be impounded, but it won't have any effect on the section 34. That is the issue. Then finally, yes, this is, in this judgment, it's on another point, but very relevant for our case, paragraph 38. As noted herein above, the learned senior counsel for the parties submitted, learned arbitrator has erred in interpreting the terms of the agreement to conclude that even where the respondent did not consume the inventory, it remained unsold. The petitioner herein was under an obligation to pay back. I am unable to, 40, I am unable to agree. Then your lordship will see 42, 41 and 42. So in our case, the arbitrators have decided the admissibility of this document. Then, at the outset, I would again remind myself of the limited jurisdiction of the court is vested under section 34, especially on the interpretation placed by the arbitrator in the agreement. In Sangyong, the Supreme Court has reiterated that the construction of the terms of the contract is primarily for the arbitrator to decide. And unless the arbitrator construes the contract in a manner that no fair-minded, reasonable person would, and that is where the arbitrator's view is not even a plausible view which can be take, or where the arbitrator wanders outside the contract and deals with matters not allotted to him, only then can the ground of challenge to section 34 be available to the party. So in our case, the arbitrators have gone deeply into the nature of the award and has held it is not registrable, it is not insufficiently stamped either, because it's not required under the Stamp Act. They have considered it and I have found correctly in my submission that it is not to be stamped. So I'll just sum up, my lord. First is on facts. This agreement does not confer a title or right in an immovable property. It precedes it, and they were perhaps in the bigger scheme of things, they will get the allotment because I've paid the money. I have not asked for specific performance or possession. Possession in this agreement says possession date is the date they start getting the rental. Correct. So I am not to get possession. They handed over the keys. In the facts, if that has not gone into, we return the keys to them. So we have not taken possession of the flat. Now, so factually, it is an investment. My only right under the agreement is to receive the returns. This is number one. Number two is that they did not raise this objection on stamp in the section 11 or in the section 21 notice answer or in their statement of defense. They annex the document to their statement of defense. They haven't even taken it in the 34. So it is a complete afterthought. Your lordship will see I didn't place the full award. All the arguments that were made, the other two arguments are novation and limitation. And the arbitrators have been impressed with the ingenuity of the counsel of my learned friends counsel. But they have ultimately said no. So this is also, my lord, in a civil proceedings, you're not meant to be taken as surprise. But we are, because this issue was not even pressed. Luckily, my lord, it was, I remember it was argued, it's in our notes, and we argued it, and luckily the arbitrators have considered it. So I'm on a better ground in that sense. So that is the next thing, that they have agreed to this document and they have never objected to it. Third is, it was admitted without objection. That's the big point, Manoj. But if it was, it's assuming my first point is not successful, that the interpretation of the document shows that it has created a right, then also under section 36, it was admitted without objection, and then that whole thing comes. And then the last point is what happens to their application. Their application, I have shown admittedly, it was made after the submission of their first defense. My witnesses were not questioned on this aspect at all. Now, there are only two things remain, my lord. Now, Mr. Gupta had argued it on the opening day. Shall I finish my submissions, or I was answering only to their stamp point? Oh, very well. I'll answer that as far as that. And if he cites any further, the last case that my learned friend, I haven't done it, the CHN.
Yes.
I wrote it down. इसमें कॉपी है सिर्फ वही पे लिखा है डाउन दिक्कत behind the again 1999 to CHN 369 paras 8 to 15. 14 is the answer. The first thing that begins with, the only question that arises for determination of the revisional application is what is the stamp duty payable on an immovable property? What on an agreement for sale of immovable property? So it doesn't concern us at all. Now, what my learned friend tried to say is that since the agreement, paragraph 14, I think, no, 13 it is, 13 and 14. I'll just place 13, Malan. The aforesaid, this is to the Bombay Stamp Act, some explanation. The aforesaid explanation makes it clear that the provision of the Stamp Act is totally different from the Act which is under our consideration and cannot help. Then 14. The explanation item number 5, added to item 5 of Schedule A, states in clear terms that an expression, agreement or memorandum of agreement, if relating to a sale, shall include an agreement to sell or a memorandum or acknowledgement in relation to transfer or delivery of immovable property with the intent to transfer. Well, in this agreement, there's no transfer envisaged. It will be, I'm paying the price as an investment.
No, they are relying upon the agreement, the clause where subsequently sale agreement will be executed.
Yes.
That they are relying upon that.
Now, the only right, well, they what Mr. Gupta said I've written, I'll just tell now. So he's saying that if any property is being transferred or intended to be transferred inter vivos in order to, if there is an instrument, then any right that is created under the agreement is this. But it has to be a right to transfer the property. Now, the parties have expressly stated that the formal agreement will be done later. This is only for the investment. And the arbitrators have already interpreted that. That cannot be reopened. Now, the other points I was saying, Malan, if my lord sees their section 34, paragraph 5, the first point they've taken is there was a novation of the contract. And they say that clauses, this assured amount part, they said interest will give you, but the assured, when it comes to 13.42%, you have deleted. Paragraph 4.
How much time you will take?
Well, I got 5 minutes. Sir. Because they have not really said anything substantial on these 2 points. I'll address these 2 points if my learned friend cites any cases on that, I'll say. the agreement was modified pursuant to a meeting. Now the arbitrators, so my first point is, well, there was no written agreement. Supplementary agreement was forwarded, we have not signed. Number one. There was no written agreement. The claimant did not attend the
agreement regarding modification.
modification. This is in 2012. The agreement was of 2006.
Correct.
Modification is in 2012. I have already paid substantial amounts waiting for my investments to fetch some returns. Then they say that, no, we had an agreement, your representative had come and it was agreed that these clauses will not be enforced. No consideration for it. The arbitrators have held elaborately on that. Now, first is that factually we have denied it. There's evidence that we have denied it. Secondly is that in their letters themselves, which I showed, my lord, when they were demanding money from us, they have not referred to this. This is a complete afterthought. Other parties may have agreed. They gave evidence that other flat owners have agreed to this. That doesn't mean I agree. So second is those letters. Then the arbitral tribunal, my lord, will just note down the paragraphs. Paragraphs 20 to 24 have elaborately discussed the evidence.
20 to 24 of
20 to 24 of the award. Award is on here, page 42.
yes. Modification. Yes.
So this defense is modified. How can a written agreement be modified by a verbal agreement? I'm not placing the entire thing, my lord, but in detail it has been considered. If the arbitrators have considered the evidence, etc., they say, and like it goes on from page 17 to page 20. I'm sorry, paragraphs, I told my lord, paragraphs 20 to paragraph 25.
24.
Right. And then they said the other modification to show that there was modification, they said we had reduced the price a little bit. They have paid that price. But we also showed that it's written here, your lordship, 26. Mr. Sen was there and I was also there. Learned counsel for the respondent argued with much ingenuity that the payments made by the claimants,
Toward the principal.
paragraph 26 of the thing.
Yes.
And the particular amount, this 2 crores 53, was in conformity with the terms of the modified agreement and should be viewed as clinching evidence of acting upon the terms. Learned counsel for the claimant, however, took the wind out of this agreement, that the argument, it should be wind out of this argument, that the respondent would have paid the balance amount consideration as and when it is asked to pay, like any other demand made earlier. So they used to raise the bill, we used to pay. There was no question. And then, so each point in any event, this modification has been to completely disbelieved. So, my lord, I was incorrect, but even 25 to 28 all goes on to a lot of time was dedicated to this. And finally, it's in 28, says that in a commercial transaction, one would expect that it would be spelt out that I'm foregoing crores by just deleting 3 clauses. All of a sudden, they have a meeting, and that was their view. And the other point, which my learned friend has taken in the 34, is limitation. Now, limitation, because they say the first agreement was 9% interest for the first year. You haven't claimed that in 2006-7, but we have said, and that argument has been.
The petitioner, but we have not argued as of yet, my lord, on
Yes,
these points.
That's what I have said. These 3 points they haven't argued. Novation, limitation. Again, the arbitrators have considered in detail paragraphs 10 to 14. Your lordship would note limitation. The arbitrators have discussed it 10 to 14. And this is a mixed question of law and fact, both within the purview and powers of the arbitrators. There are 3 senior advocates for the arbitrators, and they've considered the law on the subject. And they said, my cause of action arose when I demanded the payment in 18. Then finally, they are aggrieved that their counterclaim was dismissed. But it was specifically held that there's no question of giving possession here. He can't take advantage of his own wrong. His witness also be cross-examined. That's not there in the award, but he says that we couldn't get a tenant. He admits that they never got a tenant. They started raising this maintenance bill saying that we've given the key to your representative. So that was disbelieved. Again, completely factual issue, my lord. There is no perversity because the arbitrators have considered it. And whatever submissions I have made, I prepared a note. But if my learned friend gives a reply, because these 2 points were argued by. It was only again when Mr. Sen came back, he raised this point. I made a note on all these, but hopefully your lordship has written the page numbers which I've given those extra pages. A copy.
That's all.
Those are mine. Well, the award is the still date. They haven't deposited any money. Our execution is pending. That is the.
Yes.
May we give a reply, my lord, to his argument put forward today? My lord, any day, my lord, next week, except my lord 12 and 13, Mr. Sen is not available on that.
No. Let it be tomorrow, day after. Finish it. I'm on it. Next 14, 15, 11th, my lord, then. It will be a commercial matter.
18th. 18th.
But 11th, they are.
11th,
as a commercial matter, my lord. Because 13, 14, Mr. Sen's not there. I'm not there on 15th. I mean, 14, 15.
11 में क्या है? How much time you will take, Mr. Gupta? How much time you will take?
20 minutes should be.
20 minutes, 40, 1 hour.
He's arguing. Only on this point. Only on this point.
No.
The 34 other points are.
No, if you want to accompany, because Mr. Ghosh has also argued on that point also, that other two.
If he shows cases, I'll deal with that.
Limitation and the novation.
We have to deal with the case, judgments also, and reply to only on the point of stamp and registration. Other 34, section 34 point, that will.
2 days he argued. I've got those points from his note. Novation. Only Mr. Sen came 2 days later. He took the point. We never took the stamp point. He's argued these points. Anyway, I'm not standing in the way.
Complete it. What by piecemeal? Complete it.
Yes.
Then kindly keeps it.
We wait.
Then I am fixing on 18. You complete. No, then I am giving 2 dates. 18 and 18th and 20. Then counsel suffering for the petitioner. Counsel suffering for the respondent. Counsel for the respondent is
complete for the
petitioner. Raise for time to give reply, as well as the argument on the other grounds raised in the application under section 34 arbitration constitution of 1996. This is the matter on 18th December and 20th December 2020.
Grateful.
Yes.
Another suit for recovery of price of goods sold and delivered.
Correct.
Now, these were, my lord, PVC pipes. My lord, it's a regular transaction between the plaintiff and the defendant. Orders placed, goods delivered, sent by, my lord, trucks. received by them, challan signed, my lord, and my lord, part payments also made by them. And my lord, it was only for the balance that was due and payable. Now, my lord, we have stated in the plaint, if my lord takes the plaint first. That my lord, paragraph 4. My lord, is at paragraph 4, page 2. Oral orders are placed from time to time for delivery of diverse quantities of PVC pipes and fittings. My lord, these deliveries were to be made at the factory of the defendant, which is outside the jurisdiction of this honorable court. But orders were all received here within jurisdiction. Now, my lord, we had sent them goods under our invoices. My lord, I'll take my lord through the evidence also. Invoices with the challans. Invoices, my lord, are our invoices signed by our office. Challans signed by their person who has received it. Till date, my lord, no complaint about the quality or material of the goods. My lord, we have received part payments, my lord, which also we have said, my lord, at page number 4, paragraph number 8. My lord, we had received part payments between May 2014 and January 2015. My lord, it was 12,20,000. Last payment was received on 31st of January 2015.
Correct.
My lord, the balance due and payable that as on that date was 28,97,915. My lord, thereafter we issue the notice. My lord, we had paid our taxes. My lord, that's paragraph 12. We had issued the notice, my lord, paragraph number 18. Notice to our advocate, my lord, calling upon them to pay the outstanding dues. This notice was, my lord, the envelope was returned undelivered from the address of the defendant with the endorsement insufficient address. My lord, will kindly note once the address in the notice, which is at page number, my lord, start from page number 43, and my lord, the address in the plaint is the same. And he had come back with the remark, insufficient address.
Yes.
Now, my lord, if my lord will kindly once take the list of exhibits. My lord, we have given, my lord, in exhibit B, all the invoices. My lord, signed by us. He has identified those documents. Then, my lord, C is the challan. Challan is all signed by them of having received the goods.
Hey, Manatosh, where is the exhibits? Yeah, this one. Yes.
My lord, B is from page 2. These are the invoices. 13 invoices. Under 13 invoices, my lord, goods delivered of 41 lakhs and odd. My lord, C challan starts from 19. These are all the challans duly signed by their recipient.
Yes.
My lord, page number 32 onwards, my lord, is our bank statement. Our ledger. Our ledger, my lord, I have given proof of all the money, the details of all the money that we have received from them from time to time. That is the 12,20,000 which I have stated, my lord, leaving behind the balance of whatever is the claim of the plaintiff.
Correct.
Now, my lord, E is, my lord, the notice that I have shown. My lord, if my lord will take page number
37.
No, 40.
Notice.
Yes, that is notice 40. The envelope. It will be, in fact, the reverse of the envelope. Malad, insufficient address.
Yes.
Try beat 3 or whatever, insufficient address. So it had come back. Now, my lord, I had shown, my lord, from the report of the original site that they, to that address only, my lord, the summons was sent. My lord, though we have also made the paper publication, but the report shows, my lord, that they have entered appearance through one advocate who had filed the Vakalatnama way back in.
Have you filed that?
My lord, Xerox copy given. Original is right here. My lord, in fact, my lord will
Dated? Dated?
My lord will take this 4th October 20. No, but my lord will take this because my lord will see in the month where the month is spelled out, they've written September. So they've corrected this again.
Achha. Yes.
My lord, I've seen that correction has been made. So, my lord, I was praying, my lord, that decree be passed for the amount paid by us. My lord, 41 lakh 91,000. My lord, the details of which has been given at paragraph number 10 at page 5. My lord, we have calculated interest at the rate 24%.
Yes.
Interest, my lord, if my lord sees the invoice, at the bottom it is written interest will be charged at the rate 24% if not paid on due date.
It is mentioned.
Yes, my lord. Page 3 onwards, my lord, will kindly see. Every page at the bottom it is there.
24%. Yes.
Yes. That is what we have charged, ma'am.
That's all.
Yes, ma'am.
Consensus suffering for the plaintiff. Argument concluded.
This was a matter which was timeline was fixed by the Supreme Court. It was fixed today, not likely to be taken up. I'm only mentioning because the judge's brief of document was to be filed.
Which matter?
Item number 9 of the commercial list.
Commercial list 9. Yes. Saregama, yes.
Lordship, the judge's brief of documents was to be filed by the plaintiff. We received a letter day before yesterday that some pages were illegible. I'm only seeking leave that we may do the needful. The Lordship may fix the matter any day next week, maybe Tuesday. By that time, it will be ready.
For framing of issues.
Issues have been framed. Judge's brief of documents have to be filed.
Okay, you filed it. When it will be ready?
It will be ready by Monday. Kindly keep the matter on Tuesday.
I am fixing for the witness action. In the meantime, you exchange your.
My lord, as soon as we receive the type copy of the illegible annexures,
11
prepare
pages.
The,
My lord, 11 pages they figured, they found are illegible. We'll supply them.
Whatever it may be, you made necessary arrangement for legible copy, whatever. I am fixing a date for witness action.
Yes, your lordship.
So bring the witness along with the judge's brief of document. It will be taken on record and the witness can be taken.
The lordship will be fixing some date in January in that event.
Great.
Lordship may do that.
When it can be, see? How many witnesses of the plaintiff?
My lord, I'll have to ascertain that, my lord, if my lord permits me time to ascertain that.
11 January. What time? Witness section 11 over.
May only
11.
May only pray if the matter can be kept for 2 consecutive days, because my counsels are coming from Delhi.
So that's
when
why
the witness
that's why I ask how many witnesses.
First witness, it can be kept for 2 consecutive days if they finish.
No, if your chief will be finished, you can continue with the cross examination.
At least one day we'll do. We'll try to. If the affidavits are given in advance, we'll of course try to do.
11 and 12 is okay. No. So the queue continues there. 15, 16?
15, 16. 15, 16.
Or any other time? Other time can be given. Other time can be given. 2 p.m., 3 p.m. 30 and 31st of January at 3 p.m. 30 and 31st of January, 3 p.m.
30, 31st January, 3 p.m. Lordship.
Grateful, my lord.
In the meantime,
Item number 9. Counsel for the respective parties are present. It is submitted that though the judge's brief of document was served, but it is found that some papers of the judge's brief of document are not legible, and accordingly the same was notified. It is submitted by the respective parties that the judge's brief of document will be completed within 2 weeks from date. In view of the above, the parties are directed to exchange the judge's brief of document within 3 weeks from date. Let the matter appear on 30th January and 31st of January for witness action of the plaintiff.
Lordship will only give them a date to hand us advance copies of the affidavit. Then we will be also ready. Maybe 15 January if your Lordship records it.
The counsel for the plaintiff is directed to serve the advance copy of examination in chief on affidavit of the plaintiff witness to the defendant in advance. That is prior to 30th January 2020.
Grateful, man.
Correct. I was hoping for a date, otherwise advance can also mean.
At 3 p.m.
If they give me on 28th, it might be difficult. So if any date, 15th, 14th.
A week before. A week before.
Week before is also a holiday. 24th, 25th, we all will be on holiday.
What can be done? We cannot put pressure on that. For a week before the examination in chief.
My lord, I appear for the defendant, my lord. My lord, my witness is here, my lord. I'm really embarrassed, my lord. He was not carrying his Aadhaar card copy, my lord. I believe he
Why
stopped.
the Aadhaar card is required
My
for the
lord, he
witness?
stopped at the gate, my lord.
Huh?
He stopped at the gate. He's not allowed to enter.
Tell the court is calling him.
Lordship will give me 5 minutes, Lordship. I'm so sorry, Lordship. 5 minutes pass over, Lordship. He's at the gate, my lord. I'll try. Not 5.
Yes, next. Password is not there.
My lord, is it item number 11?
No, no, item number 5 of commercial division.
Okay, thank you, my lord.
Item number 4,
Pass over. Because now you will not get time. Other witness section is
yes,
there.
yes, I understand. Great.
Item number 5. Who is there? Nobody. Presentation of plaint, new case. How it has come here? Assign.
Yeah.
Pass over.
Your Lordship, I'm appearing for the respondent number 4, Your Lordship. I was seeking for a short passover, Your Lordship.
Why?
Uh, uh, Actually, Your Lordship, the 2 p.m. fixed matter was about to be happened, but since my seniors are on legs, they are coming. If it could be passed over for,
Has the payment was made?
my seniors will be able to make the submissions, Your Lordship. If it could be passed over,
Pass over.
grateful, Your Lordship.
Next. Pass over.
Your Lordship, item number 10, I appear for the defendant number 21. On the last occasion, Your Lordship had directed the plaintiffs to serve fresh writ of summons upon us. The summons which has come served upon my client does not contain all the papers, Your Lordship.
Who is for the plaintiff? Who is appearing for the plaintiff? Bajoria. Mr. Bajoria. Have you received the writ of summons?
Yes, Your Lordship, but the annexures, some of the annexures that are annexed are illegible, and on all annexures are.
Have you communicated?
Your Lordship, I'm not aware. We informed Mr. Bajoria, Your Lordship.
Not in writing.
In writing? Not in
Inform
writing.
him.
We will do that, Your Lordship.
You are appearing for?
I'm appearing for defendant number 21, Your
21.
Lordship. Daily motion.
Yes. What about the other?
Your Lordship.
Mr. Atalji? You are
I'm
appearing
for 27. my
27.
lord.
Have you received the writ of summons?
No.
Your Lordship, I'm praying for one indulgence. We were to file a wakalatnama. Daily Motion is a company based in France. Your Lordship, the wakalatnama that has been that was sent to us, Your Lordship, apostilled from France, is not in the executive bond paper. So the registry is not accepting it. Your Lordship.
Leave me, ना. सीधा leave ले लो ना.
Leave is granted. Special the wakalatnama without execution. Yes, nobody is here for the plaintiff.
My lord, I think Mr. Bajoria is unwell. He was unwell for a few days. I'll inform Mr. Bajoria personally, my lord.
I am fixing after a week.
My lord, kindly fix it after the vacation.
Your Lordship, another thing, some applications were filed before 2020, which weren't served upon us, and some orders have been passed. Some orders.
That's why nobody is here. I am fixing after. Let it come. In the meantime, you inform communicate in writing what paper you have not received.
Yes, we will.
And then appears on behalf of the plaintiff. Mr. Firoz Inralji, and advocate appearing for the defendant number 27. And what's your good name? Chaudhary? A. Chaudhary?
Yes.
Mrs. A. Chaudhary, and advocate appearing for the defendant number 21. Counsel for the defendant number 21 submit that though the writ of summons was received, but some of the document is either not eligible or it is not annexed with the plaint.
Once the wakalatnama goes in,
For the defendant number 7 is directed to in 21 is directed to communicate the same to the learned counsel for the plaintiff for supply of the eligible copy and the document which are not available to the plaintiff. Let the matter appear on 4th of January.
Grateful.
4th January. 4th January. 5th.
My learned friend is in some difficulty.
5th January.
Great, Your Lordship.
11, Mala, I'm appearing for the.
Lordship, I appear for defend number 1 in this.
Yes.
I'm for the
Your Lordship,
defendant number
for
2
the
and 3, my
plaintiffs.
lord.
Who is for the plaintiff?
Your Lordship, I'm appearing for the plaintiffs. I'm led by Mr. Kapoor in this matter. He was there in the court, Your Lordship.
Morning he was here.
Application is not filed by the plaintiff.
No.
Application
Yes,
is
the
What
application is filed by the
application filed?
defendant number 1 for the
Lordship, my application is there for substitution of the legal heirs of the plaintiff number 1.
Your Lordship. I'm really requesting for a not today, Your Lordship, because Mr. Kapoor has really felt unwell, so he will be coming tomorrow in the court. So,
This has been the conduct. I mean, they want to drag the proceedings.
Top of
I'm suffering. I'm a kidney patient. There's a transplant of kidney. I'm in great difficulty. Financial crunches there. I have to visit Singapore for the treatment, which incurs a lot of expenses.
Kalke, top of the list, Your Lordship, he will be here.
I'm told Mr. S.K. Kapoor was not feeling well, so he left for home.
No, morning he was.
Yeah,
there.
morning
Yes, Your Lordship.
he was waiting for this matter only.
Yes, Your Lordship.
Lordship, why I have moved this application is because I happen to be the counterclaimant in this.
Come tomorrow at a first matter in the commercial division.
Grateful, Your Lordship.
Very well, man.
Tomorrow.
Grateful, sir.
Start. Call the fixed matter.
I'm for the defendant, my lord. My witness is here.
The plaintiff is not there. The plaintiff is not
No, so that no. She went to call because.
okay.
My name is Shiv Kumar. Yes, sir. Yes, sir. ISSAR.
Sir, ISSAR.
No, ISSAR.
Resumed, huh?
SSAR.
Resume.
It's fixed tomorrow also.
Yes, my lord. It's fixed for 2 days.
Have you filed the affidavit of competency?
Yes, my lord. We have done that. We have complied with that. Mr. Sir, I believe you were in the employment of the defendant when the plaintiff was also employed by the defendant number 1.
So your question is in that duration?
Yes.
Yes, I was.
Mr. Sir, what would you have to say with regards to the general conduct and behavior of the plaintiff with his colleagues?
I mean, in general, I would say it was the reflection of where the company went from when he joined the company. He joined the company till when he left the company, meaning that his behavior probably was enough to see the company going towards losses.
Mr. SR, I believe when the plaintiff joined the defendant number one, he made certain representations as to his expertise. Can you please elaborate as to what was his expertise that he sought to portray to the management for the purpose of his employment?
Since this position was for business development, there is a set process in an in any organization. There is a set process to hire an employee, which is basically based upon a job description. And since he portrayed certain abilities which were mapped to the job description, and hence those competencies were considered to be enough to be hired in that position within the business development team.
Mr. Isar, I'm showing you a document which is appearing in the judge's brief of documents at page 109, marked as DD2.
Exhibited document? No.
What's it?
It's not exhibited.
These are all admitted documents because it's all inter partes. At page 109. You have that?
Yes, I have.
What is this document, Mr. Sir?
This is the statement of profit and loss for 2 years, comparing 2 years.
This statement is prepared for which year?
So this represents 2011 and comparing it to 2012.
Can you please indicate when this statement was prepared?
So it was prepared on 1st of August 2012.
Mr. Isar, can you please come to the last column, which tabulates the financial position of the defendant number one company for the year ended 31st March 2011.
Right.
What was the profit or loss position of the company for the year 31st March 2011?
So it says a profit and 11 in 2011. If you compare to 2012, where I can see a loss.
What was the amount of profit?
It's 2.298.833.
That is rupees 22,98,833. Am I correct?
Yes, that's correct.
That's it. Mr. Sir, can you please indicate to the court the loss that the company suffered for the following year? That is for the year ended 31st March 2012.
It's 56,473.60.
So would I be correct if I said that it's 5 crore 64 lakhs 70,360.
That's correct.
Mr. SR, who has prepared this document?
Prepared by the chartered accountants and the finance team of our company.
Who has signed this document on behalf of the defend number one company?
So there are two directors who have signed. One is Mr. S.K. Mukherjee and one is Dr. Ghui, R.B. Ghui. S.K. Mukherjee and the other one is Dr. R.B. Ghui. Ghooi.
Mr. SR, how do you know their signatures?
I mean, I have seen these signatures. They're signing different other documents in business usual practices and on other documents.
Mr. SR, what do you have to say about the contents of this document?
I'd say these are correct and true to my knowledge.
So this may be exhibited as exhibit 1, right? 3. Exhibit 3. Mr. SR, kindly have a look at the document appearing as DD3 at page 110, pages 110 to pages 2121.
1102?
110 to 121.
Okay.
What is this document?
This is a non-disclosure or the non-confidentiality agreement.
Non-disclosure
or confidentiality agreement.
This has been executed by whom?
So in this case, this has been executed by Vivek J. Agarwal, and basically there's a process in which when an employee joins a company, and it's the joining process where he has to sign this agreement as well.
Mr. Sir, if I may draw your attention to page 120.
Right.
And specifically to Article 10.
Mm-hmm.
Can you please indicate to the court what is specified in Articles 10.1 and 10.3?
So 10.1 reads as this agreement shall be governed and construed in accordance with the laws of India as applicable in the state of Haryana.
And what do you have to say about 10.3?
10.3 says disputes arising under or in connection with this agreement shall be subject to the jurisdiction of courts in Gurgaon, Haryana.
Mr. Sir, where was this document executed by the plaintiff?
So I can see on the last of it where it says in witness whereof the parties hereto have caused this agreement to be executed on this 19th day of October 2009 at Gurgaon, Haryana.
Mr. Sir, can you identify the signatures on the document?
So it is signed by Vivek J. Agarwal as an employee, and on the company's behalf, it is signed by Mr. S.K. Mukherjee.
How do you know their signatures?
Again, in the usual course of business, I have seen other documents which have been signed by them.
Have they signed any documents in your presence?
There could be some instances.
Mr. Sir, there are two other signatures on the document. Whose signatures are those?
You mean the witnesses?
Yes.
Okay. So these are two employees who were in the human resource department. One is known as Dipali Adlakha and the other one is Nilanjan Mukherjee.
How do you know their signatures?
Dipali Adlakha, Nilanjan Mukherjee.
How do you know their signatures?
They've signed other documents as well in the due course of time.
I've signed other documents as well in the usual course of time with their signatures. They have, sorry, they have.
They have.
They have.
Yeah. I'm so sorry. Mr. Isar, what do you have to say about the contents of the document, which is that pages 110 to 121?
I believe these are correct and true to my knowledge. I've not
Mr.
gone through-
Isar, would I be correct if I said that this document also constitutes a part of the entire appointment process?
That's correct.
And would I be correct if I said that the appointment letter and the annexures to the appointment letter are to be read in consonance and in reference to this agreement as well?
Yeah, I think so because these are part of the joining process and one who joins a company also needs to sign these documents.
Mr. Sir, kindly come to page 122.
Right.
Please indicate to this honorable court what is this document.
This is an appointment letter.
This document has been issued by whom? To whom?
So it has been addressed and issued to Mr. Vivek J. Agarwal.
And who has issued this document?
I'm going to the last page.
Last page is at 124.
Yes, so it has been signed by Rita Karya,
Um,
who was the authorized signatory.
how do you know her signature?
Again, she has signed many other documents.
Mr. Sir, what do you have to say about the contents of this document?
True and correct to my knowledge.
Mr. Sir, if I may draw your attention to clause 1 of the letter, does it refer to any other parts of this letter?
You mean the emoluments and the benefits?
Yes.
I can see there are two annexures, which is annexure 1 and 1A.
Mr. Sir, kindly come to page 125 and 126.
Right. I have them here.
Are these the annexures which have been referred to in the letter of appointment?
Yeah, these are the two annexures mentioned in section 1 of the appointment letter.
Sir, if I may draw your attention to clause F, the subclause 5F at page 124 of the same letter. 5F.
Clause 5 within bracket F.
5 bracket F.
Of page 124.
At page 124.
I have it.
Does it refer to any other agreement?
It refers to an agreement says as key employee agreement, which is attached as annexure 2.
Mr. Sir, kindly turn to page 129. Is this the document referred to in clause 5F at page 124?
Yes, this is annexure 2 key employee agreement.
Mr. Sir, Kindly come to page 130. Are the terms of clauses 1 and 2 are similar to the non-disclosure agreement? And or the substance of it and the intention of it are they the same?
Yeah, I think the essence is same.
Mr. Sir, kindly turn to page 137. So just 1 second. Strike that out. Mr. Sir, kindly come to page 136. In fact, 135, sorry.
Right.
Who has signed this document?
Signed by Dr. Rita Karia.
How do you know her signature?
She has signed many other documents in Geneva.
What do you have to say about the contents of this document?
Correct and true to my knowledge.
Mr. Sir, if you turn to page 136, you will find some other signatures. Whose signatures are these?
So there are two here. One is signed by Rakesh Kumar Bansal, and the second is Bansal, and second is Dipali Adlakha.
How do you know their signatures?
I've signed many other documents in Geneva.
Mr. Bansal, please turn to page 137. Mr. Isar, what is this document?
So this is an incentive plan.
Does it refer to the process of appointment?
Yeah, this refers to the process of appointment.
Mr. Isar, can you please indicate to the court what was this was offered to whom? This incentive plan?
So this incentive plan has been offered to Mr. Vivek Agarwal.
Mr. Isar, this incentive plan was offered to Mr. Agarwal in what capacity?
As a Vice President, Global Business Development.
Mr. Isar, what was the term for which this incentive plan was valid?
It says financial year 2010 and 2011.
From the said incentive plan, can you please indicate to this honorable court what was the maximum amount of incentive that Mr. Agarwal could have earned under the incentive plan?
So that's under row number 4, which says 3%, subject to a maximum annual amount of rupees 48 lakhs.
This incentive of 3%, subject to a maximum amount of rupees 48 lakhs, would be payable to Mr. Agarwal upon fulfillment of any particular condition?
This is the very condition. The very condition.
Can you please elaborate? What is the condition on which he would earn 3% incentive?
So it reads as from US 3 million and above, to get the business of 3 million and above.
Mr. Isar, when Mr. Agarwal left the organization, you were in the employment of the organization?
Yes.
So from the time of his employment till the time he left, what was the value of business brought in by Mr. Agarwal to the Defend Number 1 company?
I don't think I recall from top of my head that he brought any business.
So if he did not bring any business, what was the incentive that he would have earned under this scheme?
That's under row number 1, which says nil or even up to 1 million. So there's a slabs to earn an incentive.
So in the event Mr. Agarwal brought in business of $1 million, he would still earn no incentive. Am I correct?
That's true.
Mr. Isar, who has signed this document?
This has been signed by Mr. S.K. Mukherjee.
In what capacity?
He was a director.
How do you know his signature?
Many documents have been signed by.
What do you have to say about the contents of this document?
Both of these are true and correct to my knowledge.
Well, the annexures at this defendant's document DD3, pages 1110 to 137 may be exhibited, my lord, and marked as
Pages
4.
1102, 137 of judge's brief document of the defendant.
Of the plaintiff. Well, it's a composite.
Of the plaintiff are marked as exhibit 4 collectively. For collective.
Mr. Isar, I'm showing you a document which is appearing as DD4 of the judge's brief of documents at pages 138 to 141. Kindly tell this honorable court what is this document.
You said 138 to 141?
Yes.
Okay. So these are various policies. These are one of those or two of those policies, and under the Human Resource Department. And this basically, the first one that I'm reading at page 138 is own your car policy. Own your car policy. Yeah.
This, would I be correct if I said that it refers to the leave travel assistance emolument, which was an entitlement of a vice president of your organization?
That's true.
What do you have to say about the contents of this document?
True and correct to my knowledge.
Mr. Sir, this has been issued by whom?
So this has been issued by Mr. S.V. Ramanan, Vice President, Human Resources.
So these documents can be exhibited, my lord.
Page number 138 to 151 of the plaintiff judge's brief of document.
Defend number 1 is different.
Exhibit 5 collectively.
Mr. Sir, what is this document?
This is an order sheet.
You can look at the entire document.
Okay.
What about
Written statement.
উনি আনসার দেবেন তো See, sir, you can have a look at the document. There's no problem.
Mr. Ghosh. Mr. Ghosh. How it can be? What you question you put? What you wanted to put the question? Leave aside that. That is a court document. Written statement is handed over to the witness. Yes, put the question. What question you want?
What is this document?
This is a written statement.
This has been affirmed by whom? Please come to page 10 of the document.
So this is signed by Mr. Vijay Kumar Sharma.
How do you know his signature?
He has signed various documents. He is in the company.
Mr. Sir, what is the designation of Mr. Vijay Kumar Sharma?
He is in the administration department.
Mr. Sir, kindly come to page 11.
Yeah.
Kindly have a look at paragraph 1. Can you now indicate as in what capacity he has affirmed this document?
Authorized signatory.
Mr. Sir, who has prepared this document?
This has been prepared by our advocates based upon our discussion. Based upon our discussions and instructions.
Mr. Sir, what do you have to say about the contents of this document?
I think these are correct and true to my knowledge.
Mr. Sir, can you please encircle the signature of Mr. Vijay Kumar Sharma at pages 10 and 11? With red. So the written statement may be exhibited with the signatures as five. Well, that's procedure. That's well, defend number 1.
Written statement of the defendant number 1 is marked exhibit 6 and signature. In paragraph page 10 and 11, we marked as exhibit 6/1 and 6/2.
So I'll come back tomorrow. I'll review. I think I don't have too many questions anymore.
Further,
my lord, I'll just come back to because
you
it's
will
kept
not complete today.
I think it's complete. I'll just review the deposition once. If I've missed out anything, it's
15
fixed for
minutes
tomorrow at 2 p.m. again.
15 minutes is there.
Well, we can start its cross-examination. We'll come back tomorrow. Well, because it's already there tomorrow. So we'll just have a look at it. I don't think I'll keep.
Tomorrow you will start cross. Please step. Appearing for the plaintiff, appearing for the defendant. Examination in chief of the defendant resumed today and during his evidence. marked as exhibit 3 to 6. Counsel for the plaintiff, counsel for the defendant prays for time. Examination chief is deferred. Let the matter appear tomorrow at 2 p.m. Yes. Come tomorrow at 2. Great. Next.
My lord, I appear on behalf of the plaintiff, my lord. My lord, in this matter, my lord will kindly recall that Mr. Aurik Banerjee was appearing on behalf of the defendants, my lord. I have an application under Chapter 13 of the High
Yes,
Court.
hearing is
Code.
going on.
Yes, my lord. We have to conclude, my lord. So I understand, my lord. There's another matter fixed at 3 p.m., my lord.
That's right. Okay, let it be on in the list itself.
My lord will kindly fix a date and a time subject to my lord.
So that's in the commercial matter. That's why I'm not fixing a date and time. Let it come tomorrow. It time permit tomorrow. I will do. All the originals are list in the ordinary matters. With commercial, nobody's here. Commercial matter, anybody's here?
Yes, yes.
Which matter?
Item number 5.
Yes. You are for the?
Yes.
You are for the plaintiff?
My lord, I beg to appear on behalf of the plaintiff.
Who is for the defendant?
My lord, this has come up as presentation. It is an assigned matter before your lordship. I'm praying for leave under clause 12, lordship. The contracts were all, purchase orders were all issued in favor of the defendants from the plaintiff's office at Bagbajar, which is within the jurisdiction of this honorable court. Lordship, we had gone for mediation. There was this.
Where is the mediation?
There is a non-starter report. Lordship. Page
number 73.
Page 73, Lordship.
Acha, that one. Yes. What is the suit about?
I beg your
pardon. What is the suit about?
Suit, Lordship, the plaintiff claims damages on account of purchase orders which were issued in favor of the defendants for performance of certain upgradation work at its factory in Haridwar. Lordship, they could not do that, subsequent to which 2 purchase orders which were issued in the favor of the plaintiff were called back by the assignees of the purchase order. Lordship, consequent to which the plaintiff has suffered losses. Plaintiff is a company which is engaged in manufacture of medicines, Lordship. Purchase orders were issued in favor of the plaintiff. Those were called back due to the non-performance of the task which was assigned to the defendant.
Correct.
Lordship kindly takes up paragraph 23, which is at page 14, Lordship, where the cause of action of the suit has been described, Lordship.
There is no arbitration.
No arbitration clause, Lordship.
There is no arbitration clause.
Mediation, arbitration.
Leave under which?
Leave under clause 12, Lordship.
I'm great.
Six. Contempt. Item 6 is my application for contempt. My lord, there's that matter, my lord, where 8 crores was admitted. And my lord, first installment of 1.
Inform your lordship's desire, my lord, to the client, my lord. My lord, your lordship, kindly look at the email which you have received through my client, my lord. The paragraph 3, my lord, if your lordship.
When the cyclone came?
Lord,
Cyclone came on 4th of December.
Lord, I'm not fully aware.
Not the 28th November.
Lord, I'm not fully aware, my lord, of the cyclone. Lord, I'm absolutely on your mercy.
Kindly come to the paragraph 3.
Yes, I don't know, Lord, this.
Balance amount one could not be arranged due to the commencement of Michong cyclone.
28/11 he says, but my lord, I have personally no idea, my lord.
Started on 3rd of November, December.
Maybe, my lord, Joseph may be right. I have seen only 2-3 days back, my lord. Lord, he has said, Lord, he'll pay by 12th, my lord.
I've seen the last paragraph that they proposed to pay it by 12th. Today we are on the 5th. That's a week away.
Okay, all the person may be present before this court in person on 12th.
12th
all contemners will appear before this court.
And for the contemner number 6.
Whatever it may be. Maybe. By an order dated. By an order dated 17 November 2023. This court has passed an order.
Have dispensed their personal appearance. We are representing him.
By an order dated 17 November 2023, in terms of the undertaking filed by the contemners, this court has set out the settlement, out of which 1.5 crore is to be paid by the contemners by 30th November 2023.
For contemner, 4 million.
But out of 1.5 crore, only the 50 lakhs have been paid by the contemner. On when it was paid?
Lord, I have sent the pay order, my lord.
30th November 2023.
Lord, I sent it on the 1st, my lord. I must be.
In the learned counsel appearing for the contemner number 4 has handed over the letter dated 5th December 2023.
It's an email.
It's an email, my lord.
Email dated so and so, wherein in paragraph 3 it is mentioned as follows. Record this. The contention made in paragraph 3, it's totally incorrect, as on 30th November 2023 there was no cyclone. Full stop. The content number 4 in paragraph 5 has stated that he will pay the amount of rupees 1 crore to the plaintiff on 12/12/2023 with interest at the rate of 18% per annum. In view of the above, this court find that all the contemners required to be appeared before this court in person on 12th November 2023.
But 8 and 6, my lord, have shown mercy on the last occasion, my lord. We have nothing to do with
That's why the mercy, this is the faith of the mercy. This is the faith of the mercy.
We are caught in the cross.
Go and challenge it.
Well, can you produce the records in the last?
No problem. No problem.
My lord, contemner number 6 is bedridden, my lord.
No problem. If he will not able to come, then our Calcutta police very efficient to bring.
See, my lord, they have shown an affidavit to that effect. My lord, we have shown an affidavit to that effect. The Calcutta police have recorded in the police report that
I will see to that. I will see on 12. I will see on 12.
My lord, have already dispensed with the personal appearance, my lord.
That's not if it is dispensed, it is not the power of the court to bring the appear in person.
We have submitted our affidavit to that score, my lord. Kindly absorb the contemner now.
Okay, next. Call the next one.
My lord, on the last occasion, my lord, that representation through councils will be sufficient, my lord.
Okay, no problem.
Kindly do not, my lord. My lord, we have nothing to
Sorry.
do with this list, my lord. We are asking the order. My lord, we scrutinize our conduct of the last occasion. Thereafter, pass the order.
Taking the benefit of that, you are
taking. My lord, kindly do not take the amiss, my
so
lord.
you could have been pressurized them to pay the amount. Why you are not pressurizing? You are in bed.
My lord, we are the bona fide-
Just call the next matter. Who is on the next matter?
We are caught in the crossfire, my
My
lord.
lord,
Kindly, my lord, with
I
respect.
appear
My
for
lord, kindly dispense.
Yes.
my lord, I appear for the applicant, my lord, in this matter. My lord, the defendant numbers 1, 2, and 3, my lord, had filed their affidavit in opposition to my application at a belated date. My lord was pleased to extend the time, my lord, for filing of the reply. My lord, we have already served copies upon the defendants.
The matter is ready.
Lord, I appear for the defendant number 6, my lord, led by Mr. Ditabrata Mitra.
Now, my lord,
Decree passed.
if I may, my
Application
lord,
for amendment of suit by the plaintiff after passing of decree.
No. Wrong submission. Already there is an order.
yes.
That's why the decree was not passed.
Lord, there was an order.
Decree was not drawn.
My lord, could not be drawn, my lord, which
Grateful,
is
my
why, my lord, prayer B, lordship will see, my lord, for amendment of the cost
What is
paper.
your submission?
My lord, I say, my lord, that this, my lord, could. Lord, my senior, my lord.
It's a weird situation, but my lord, it works as it is. So decree is in place, but it's perhaps, my lord, a incurable defect. So, my lord, I don't know how they will rectify, because the provision they've mentioned that does not give any curable instance. So, CPC to them.
Yes, whose application? Your application?
My
Ready?
my lord, it's ready, but my lord, I am told, my lord, your lordship has got a 3 p.m. fixed. So it will take some time, my lord. Because, my lord, I need to, my lord, demonstrate, my lord, the scope of section 152 in case of an omission. My lord, can be by the any of the parties or on the part in any inadvertence on the part of the court.
Omission of?
Omission, my lord, to record something. Because, my lord, I'll indicate this matter, my lord, was transferred to the commercial division 152 of the Code of Civil Procedure.
Lord, it refers to amendments of judgment, decree, or order.
Yes.
This has nothing to do with that.
With that.
Perhaps, my lord, that
Kind-
is what I
kindly-
need
no,
to
No,
demonstrate.
kindly see prayer B, my lord. Submissions contrary to the pleadings cannot be permitted. Kindly see prayer B, my lord, of the application.
Not about the
The
pleadings. my lord.
thing is that this court has passed an order for transfer of the suit,
Yes.
but you have not taken recourse of that, and you continue with the
Correct.
No, that is, my lord, perhaps where I will join issues, my lord. Because the court, when it had passed the order, my lord, for transfer, it has not set out any timeline in terms of section 15(4) of the Commercial Codes Act. Now, my lord, subsequent thereto, my lord,
It is necessary. The court has to fix the time for.
After
my lord, that
passing
is
of
where
the decree, my lord, no
my lord,
timeline fixed. So after passing of
that
the
is, my
decree,
lord, only the juror portion of the my lord, the pleadings, my lord, that is exactly what is being sought to be amended, my lord, insofar as, my lord, because over here, my lord, the situation is there was a decree passed. My lord, the transfer order for transfer was passed, my lord, as long back as in November 2017. Now, my lord, thereafter, my lord, for all material purposes, my lord, this suit was tried as a commercial suit. My lord, in fact, there have been orders passed, my lord, reported judgments, wherein this suit, for all practical purposes, have been treated to be a commercial suit. The trial had commenced, and my lord, that is in compliance of the provisions laid down under the Commercial Codes Act. The amendments, my lord, which has been caused to the Code of Civil Procedure. So, my lord, and in fact, my lord, this is
the court has passed an order for transfer of the suit, and the parties have not taken it. What will be the fate of the order?
my lord, that is perhaps
It's a simple question.
yes, my lord, that is where I say, my lord, perhaps section 152 of the Code of Civil Procedure, my lord, can be invoked. This, my lord, what I submit, my lord, is there was an error which needs to be rectified.
Error where?
My lord, error in, my lord, amending, my lord, the jurat of the pleadings in the suit, the plaint.
Plaint 152.
152.
What you are
No,
making submission,
it's
sir?
not, my lord. I'm not under order 6 rule 17, my lord.
Not your 152. What the 152? Can you read it?
My lord, 150, read with 153.
Of judgment and decree.
Amendment of judgment. My lord, because that is, my lord, in fact, Mr. Ray, my lord, is there online, my lord. I'm being led by Mr. Ray.
Yes, Mr. Ray. Of the 152.
My lord, your lordship will kindly appreciate two things. My lord, I'm on a better footing in this case, my lord. My lord, there was a direction by your lordship's court that it should be in the commercial use. Now, my lord, I don't know whether my learned friend has shown at least 2 or 3 times when it appeared under the commercial heading. And my lord has been taking up matters. Your lordship, there is no dispute that even the admission denial, there's a substantive order passed by the erstwhile or the honorable judge who was taking up the matter then. Then also there was adherence to the Commercial Courts Act, complete. Now, my lord, when the decree was passed, your lordship, the judgment also records it as a commercial court, commercial division. Now, when I go to the decree to be drawn up, my lord, the question arises that the plaint does not mention it as a commercial division.
Correct.
Now, my lord, I have been trying to find out under which provision is this possible or required to be done.
That's why.
My lord, yes, my lord. But today, my lord, the practice procedure rules have come out, but I don't think that will be governing this plaint because I think before that the decree was passed. Now, my lord, if your lordship kindly sees the provision for transfer of pending cases, my lord.
15.
My lord, if your lordship kindly takes
Section 15.
15, my lord. But I'm hoping that I get to understand what is going through your lordship's mind, which I generally do when your lordship takes up a matter. But let me try and prod a bit furthermore. My lord will kindly see, my lord, section 15.3. My lord, there is no problem about the applicability of section 15.1 and 2. Yes, it was pending. It was decided that it should be transferred. Order of court. I don't have a problem with that. As a matter of fact, my lord, this judgment, or rather this matter, will have the history of recording evidence by affidavit of evidence for the first time in the High Court at Calcutta. Because well, this was the first commercial suit where affidavit evidence was directed. Otherwise, well, we do not take evidence by affidavit of evidence relying on the original side rules. So that was also done. Now, one kindly see 15.3, where any suit or application, including an application under the Arbitration Conciliation Act 96, relating to a commercial dispute specified value shall stand transferred to the commercial division or commercial court under subsection 1 or subsection 2. Now see, the provisions of this act shall apply to those procedures that were not complete at the time of transfer. So, my lord, whatever has happened has happened. What would apply? The procedures laid under the Commercial Courts Act on transfer, the place where it had stopped in a regular division, from there the procedure will be followed. Today, my lord,
Is correct. Now, here,
Well-
here all the things in the commercial division, but in the plaint you have not amended. How it can be amended now?
my lord, that is what I'm trying to say, my lord, with humility, I can say, my lord, the act safeguards that. Because the act says the procedure will be followed under the Commercial Courts Act after it stands transferred. Now, when this was transferred, my lord, but I believe the written statement had also been filed. So, my lord, the procedure would start from the point of admission and denial. So that would not require, my lord, with humility, I submit, your lordship will kindly appreciate section 3, sorry, 15.3. Or else what would happen? Everything will have to go back. My lord, this might be an easy route. I will kindly appreciate. Because what is sauce for the goose is sauce for the gander. This might be an easy route. This might be an amendment of the plaint. I write commercial division, finished. What happens if the admission and denial had taken place earlier? It wouldn't have been in the prescribed form. Then, my lord, we'll have to turn the clock back again to make the admission and denial in that 5
column way. So, that is why the legislature safeguards this, saying that the procedure from the date of transfer will apply.
That's correct. That is not the problem.
So therefore, we never had the opportunity to amend it, because the act, with humility I submit, your Lordship kindly consider, the act does not require an amendment. It's your Lordship's order for transfer which is there. Kindly sees, I'm again referring to 15.3, the provisions of this act shall apply to those procedures that were not complete at the time of transfer. Has it got section 15?
I am there only.
Where any suit or application relating to commercial dispute shall stand transferred to commercial division. Now, under section 1 or 2, comma, the provisions of this act, so that's the Commercial Code Act, shall apply to those procedures, as in whatever procedures have taken place, not those, but those procedures that were not complete at the time of transfer. So my filing of plain written statement had all been completed before the transfer.
It's not the point here, Mr. Ray. Only at the point that all the court has not stated that you have to complete all the procedure, but you have not amended. Neither you have pointed out that the office has to amend the cost title. Correct. So now the court has passed a decree under the commercial division, but how the drawn if the plaint itself is not in the commercial cost title is not of a commercial division? How the decree can be drawn? That is
that is my submission, that was needed, but kindly does not take me amiss, that was supposed to be done by the department itself.
Correct.
I'll point out why. So the direction was given to the department, because Manoj sees in the event when kindly reach 15.5. Kindly reach 15.5, if your Lordship's court does not transfer, then only I can come up and make an application.
Correct.
So it was the department which needed to do it. But this could be a departmental, departmental direction to make this. This does not change the procedure, does not change the decree, nothing. And the parties have.
So you come on the next day?
I can, the only thing which is, I think, troubling your Lordship, that an amendment is required or was required. And now we are at the end of the procedure, decree has been passed, how can I amend? This is what is troubling your Lordship. I was trying to submit that amendment may not be required. I'll try and assist your Lordship there. If not, can I amend the plaint after decree? I will try and assist your Lordship.
The only thing, if whether after the decree it can be amended, and that is also not the fact, only with regard to the cost type.
Yes.
That is it, but it will only include comment. Kindly, if your Lordship kindly does not take me amiss. Your Lordship's order, what happens? Orders are generally supposed to be the cost title. Your Lordship's last order includes commercial division.
That's why I have done in the commercial division.
So that's why, even earlier to your Lordship, earlier to your Lordship.
To be passed taking into consideration of the plaint, but the plaint has not been done as per the order. It has been running in the commercial division.
Yes, and as of not only that, procedure has been followed of the commercial division. Because at every instance,
But the problem here, if I will call the departmental person also, my lord, this is the this is the proceeding going on. This is the procedure we are adopted. They are not going to any law and anything.
That is what I will try and show, maybe that procedure is not contemplated. Even after the rules which has come out, I'll try and establish that. I think that will help us out. One thing is good, it must not make any substantial change in the decree at least. If that would have been the case, then it would have been very difficult, uphill task. So that is why,
that's why I kept in the list. Otherwise, it will be difficult for you also, for the court also.
Keeps it any day, whenever your Lordship wants.
For the respective parties are present.
Preferably in January,
Counsel for the plaintiff has argued that the matter at length through virtual mode, but due to paucity of time, argument could not be completed. Give the date.
Actually, what December 20.
11 January.
11th January.
I'll be very grateful.
Grateful.
Extended holiday.
12, 13, 14.
12 is a holiday, 12 January.
I am not consulting any. So what do you want? Another date?
After that week.
So take the benefit of
No,
weekend.
Lord. Yes, there can be a longer weekend. So on the next.
No, my lord, we'll do it on the 11th, my lord. We have a decree to proceed with. My lord, my learned friends are proceeding in Bangladesh. But I am not agreeing with that. But kindly takes it upon the 11th. Grateful, man.
We would say there is nothing.
Appear for the plaintiff. The defendant's witness is to go in.
चला ही लो गर्मी से Dependent witness.
Yes, my lord. The witness is there.
This place.
My lord, may I tender the documents that I have submitted already?
Examination chief filed. Affidavit of evidence filed.
No. This is the judge's brief of documents which I have tendered on the last occasion.
But no inspection has been given.
Nice.
Inspection. None have been offered.
After the evidence.
Let her do this.
Achha, that additional document.
Could you please tell your name?
Whatever I do. By the way of evidence. By the way of evidence. I shall speak to no part of it. So, false. And I shall not consider. Pankaj Kumar. Pankaj Kumar. Yes. Ramavatar Mandal. RAMAWTAR MANDAL. 40 years. Back. I'm employee of Punjab.
Residential address.
Yes. Originating from Bihar, I'm posted here in Kolkata. Vishnu Regency. VISSNU.
My lord, may I tender the documents? First document is the modification of the terms of the Modification of the terms of the tenancy dated 3/1/92.
Show the document, let the witness say what is the document. You show the document,
Yes,
the
yes,
witness must say.
Just there.
Which document you want to show the witness to the witness? From where?
Modification of the terms of the tenancy. 13/1. 92.
Fine. Judge's brief, no? Fine. Which document you want to show?
The modification of the terms of tenancy.
From which?
13/1/92.
From which document?
This is the
Judge's brief document?
Yes, I have this document.
No, it is the court document. Which page number?
X.
Page number?
14A and extra X. No, this is not the notice.
Nahi.
Okay.
What is the document? Judge's brief document of?
Huh. Same one. It's the same one.
Yes, what is your question?
The question is like, you are aware of the contents?
Yes.
This is the document, original document.
Yes, my lord. I am aware.
What is the document?
This is the modification in tenancy, sir. Terms of tenancy.
Proposed terms of tenancy.
Yeah.
Kindly go through it. Are you aware of the contents?
Yes. Yes.
This is the correct document?
Yeah, correct document.
Then the next document is the minutes of meeting held on 25th.
Madam, you are not ready, I think so.
I think
Yes.
well, the defense will get ready.
I'm not.
Either get your senior or take the help, how the witness is to be led. This is not the way to lead the evidence.
Then, my lord, a short date may be given to me. I'll be prepared.
Who is your senior?
Next date.
Who is your senior?
There is no senior
You are
engaged.
conducting on.
I'm doing it on my own.
My learned advocate on record does not have the vakalatnama also.
No, I have filed the wakalatnama.
Have you filed the vakalatnama?
Yes, I have.
It's not the way to lead the evidence.
No.
It is your witness. You have to go by sequence.
Witness can't show him and say you are unaware. What is the document? Prove the document in accordance with the state.
My lord, next week, if your lordship keeps a date, I'll be prepared on this.
Problem next week. Then it will go
Or
to
this week, maybe Friday, I'll be
then it will
prepared.
go to next year.
Ma'am. What price?
Where from you came?
I'm from Calcutta only, sir.
Let's give a early date. I don't think it's very long. 4 documents, they're all common.
4-5 documents are only there.
Questions should be put. I can't put
That's
the
why
questions.
neither the court nor see other side will support you.
And I'm sure this gentleman wasn't in the bank in 92. So you can't say I am aware, like I can't object to everything, but
No, he was not there. He was not there.
You have to come systematically how the witness to be.
If they're
be-
wanting to
how the
give evidence,
document is to be exhibited.
I will do that, my lord.
তো বলছি পড়াশোনা করো জিজ্ঞেস করো লোককে I can't tell you. I could have told you, but then where on my client for me to tell you?
Keep question.
Actually, দেখছো এত চিফ হচ্ছে সব এক্সামিনেশন সেকশন তো not for anything else, so not for the matter. Find out what are you trying to do.
As per the prayer. नहीं concessions appearing for the plaintiff, concessions appearing for the defendant.
ঠিক আছে তুমি করবে
Dependent
pressure. You have to be able to do it. To ask a question.
Dependent witness is
just asking my questions.
And examine in part, but due to the personal difficulties of the counsel for the defendant, examination chief of the dependent witness number 1 could not be completed.
Little bit. Any textbook couldn't
Let the matter appear on. Give the date. 19 January at 3:45 p.m.
Also, 19th of January.
19 January 3:45. Come ready with that.
But it hasn't begun today then. The Lordship will then his name
Whatever that may remain.
Nothing has gone in. I don't know. One
Leave
question
aside.
gone in.
As per the prayer, madam, as per the prayer made by the counsel for the defendant, is adjourned.
And the witness so and so was present. You can Lordship.
So and so appearing. Okay. The dependent witness is present, but due to personal difficulties of the counsel for the defendant, the examination could not be conducted. The case is adjourned. Let the matter appear on 19 January for witness action of the. Yes, 19 January.
19th of January. Very good, my lord.
My lord, I beg to appear on behalf of the plaintiff, my lord.
Yes.
It's an application of the plaintiff. If your lordship recollects, this was a matter, my lord, relating to framing of a scheme with regards to maintenance of a property in Chaurangi Road, my lord. My lord, we had advanced arguments. My lord, at that time, a receiver had been appointed by your lordship to go to the property and see the state of affairs, and thereafter, if required, frame a scheme by all the contesting defendants and the plaintiff. My lord, the defendant number 1 is perhaps contesting the application. Defendant number 1 is the company which is maintaining the entire building single-handedly, my lord. That is why this plaint. In the suit, all that we pray for is that there are several occupants in the building and there requires a framing of a scheme so that everybody can put in the maintenance. Whatever amount is generated from the maintenance, that can be used in a proper and functional manner, my lord. Your lordship on the last occasion had heard us. The report by the receiver had been taken on record. They had chosen, the defendant number 1 had sought for time to file exception to the report, my lord. Lord, such exception we have received day before yesterday, my lord. Lord, if your lordship, if they file the exception, my lord, it'll take 10 to 15 minutes time, my lord. What I was praying for, Mr. Bose was leading me in the matter. If your lordship would be pleased to fix the matter someday, my lord, 10 to 15 minutes of time, and thereafter, my lord, perhaps certain prayers in my application.
Exception.
My lord, in the exception, my lord, we have indicated that this is a trust property. And the trustees are supposed to be, are basically concerned with the management and control of this particular property. And by a power of attorney, the trustees have entrusted me, the defendant number 1, to look after the property and to look after the property, the maintenance, pay taxes, etc. That all has been given to us by the trustees. Now, my lord, with this association being formed, the prayers made by them is with regard to formation of an association, including all the lessees at the property, my lord. The difficulty is that we are answerable to the trustees. We have been given the responsibility to look after the maintenance of the trust property. Now, there are about 1 crore 54 lakhs is payable in total as far as the maintenance dues are concerned. They have made certain payments in November 2023. Apart from that, taking that into account, still around 1 crore 54 lakhs remains payable, my lord. So our submission, we are willing to form an association. We are willing to talk to the trustees to allow us to form an association subject to payment of this amount, my lord, because before such payment is made,
Yes.
we have put in a chart of the amounts and who is able to pay how much amount in the exception, my lord, at page
11.
Page 11, paragraph 15, my lord. This remains due. Still remains due and
That's
payable
why,
by.
see, unless they are all are the tenants.
Yes.
They are the tenants.
Yes, they are lessees. Yes, my lord.
Tenant,
Yes.
lessee, whatever it may
Yes.
be.
Yes.
Correct. There is a dispute with regard to this rent and all these things.
Yes.
It is your
They have earlier also they have paid to us only. We have been looking after the management since 2015.
Now there is a dispute not paying whatever it may be. Now
Yes.
this is your claim.
Yes.
And you are claiming that you are the power of attorney holder of the trustee.
Yes.
Correct. And but these tenants are not the not in the trust. Trust
No,
is
even
different.
I am not in the trust. I am the lessee. The trustees have given them. I am in occupation of about 75% of that property. I am the main lessee of the entire property, and therefore I have been given the right to look after the management and maintenance of that property, and I have been doing that since 2015, my lord. So the difficulty is, my lord, if an association is formed already and they come into the association and the maintenance is now looked after by the association, probably there'll be several difficulties as far as these earlier dues are concerned because they have not cleared it, and we will also.
My lord, I am for the respondent number 9 in the matter. I beg to appear here, my lord. I will be joining on one issue. So far as the dispute regarding the payment of these maintenance charges and other, my lord, against me and some other tenants, other lessees, sub-lessees also, my lord, there is the other suit which is pending before the other bench. And that is the subject matter of that suit. That cannot be, my lord, ventilated here, my lord. Only that is why I am appearing because I have already left the premises and I have no other intention to poke my nose here, my lord. But we'll only think that this cannot be gone into. The liability of payment of maintenance, whether they are entitled to or not, that is a subject matter of separate suit, my lord.
Perceive of a situation. My lord, there are several tenants in a building. The tenants and every occupant wants the building maintained. My lord, today there is some disputes admittedly between the parties who are residing and occupying in the building. For maintenance, a party comes forward, files a suit where we are claiming, all that we are claiming is an association should be formulated for transparent management of the building. But now what happens, the moment we file this suit, there are claims that are espoused by the defendant number 1 with regards to the maintenance costs that they have incurred in the past. Lord, it's converted into perhaps a suit for recovery of money. Lord, now kindly perceives of a situation, the receiver files a report. The limited purpose why the receiver was appointed was to go to the property to see the situation, the status of affairs, whether the parties are ad idem for formation of an association. In the receiver's report, the receiver specifically mentions that a meeting was conducted, the parties were ad idem that an association should be formed with certain reservations, which has been duly recorded by the receiver in the minutes. But now, after the receiver records these in the minutes, they want to file an exception. The exception that has come forward, my lord, if your lordship takes into consideration the exception, is it in fact an exception to the report filed by the receiver? My lord, the entire stand which the defendant number 1 took on affidavit, when they used an affidavit in opposition to my application, at that point in time was the moment when these points with regards to whether trustees will manage, whether somebody else will manage, what has to be done, had to be taken. None of those stand with regards to trustees managing the property has been taken. Today, when an opportunity has been granted to them to file an exception to the report, my lord, they come forward with a peculiar new stand that the trustees of the building are the persons who have to manage the property. My lord, perhaps was that the scope of the exception that they were granted by your lordship? And my lord, in the exception, have they even made one statement to the effect saying that no, they do not want the association to be formed by mutual consent of the parties in the building? No, my lord, because perhaps that's not what they also want. They also are agreeable for formation of an association, but provided this suit becomes a money suit for recovery of their dues. which alleged dues that they have paid for maintenance of the property. My lord, may I take your lordship?
My lord, there cannot be a counterclaim by one defendant against the other defendants, my lord, in a suit.
Trustee. We have no objection if the trustees manage the property. We have no objection. Somebody has to manage it. If the trustees agree to manage it, the trustees have given a long-term lease. This is undisputed fact. And the long-term lease, my lord, every long-term lease, my lord, requires the lessees to maintain their. Now there are admitted common areas, and my lord, this is not a house or a two-storied building. This is a multi-storied building with 2 blocks. So my lord, we are talking about lakhs and lakhs of square feet of common space, about 6 lifts, amenities, pump. There's a high tension electricity supply. My lord, basically, my lord, we are looking at maintenance which can run into, if I don't know, but it should be lakhs per month. But some mechanism has to be there. Somebody cannot just steal the show. I can understand that you've done it, but all good things come to an end. You've done it, very good. We'll give you brownie points for that. But the question is that, my lord, today, Lord, here is a situation that, my lord, today you are now raising an issue that the trustees, trust property. Trust is the owner of the property. The trustees, it's a Devotto property. So the Shevayats have given the leases. My lord, 4 floors are to me, 3 floors are to them, and there are several other occupants to whom leases have been granted. There are sublessees as well. So, my lord, in the usual course, my lord, the West Bengal Apartment Ownership Act applies. But in this case, since it's a completely non-residential building, West Bengal Apartment Ownership has no manner of application. So, my lord, if your lordship applies the principle of that or the other principle, association formation is a matter of, my lord, it inevitable. So there cannot be any other way by which the building can be managed. So, my lord, my respectful submission based on the exception that has come, my lord, there is no substance in the exception. What is he objecting to? So, my lord, there cannot be an objection to the maintenance. He says, trustee, we will give notice to the trustee. Trustees can be a part of the association. Trustees are the owners of the building. If the trustees want, trustees can be the part of the association. We have absolutely, I mean, nobody can have any grievance. My lord, now, my lord, as under the, my lord, the Calcutta Gujarati Education Society and Popat Kotecha judgment, now it is, and the amendments to the Calcutta Municipal Corporation Act and to Premises Tenancy Act, occupants are the persons liable to pay municipal rates and taxes. Now, if the burden of municipal tax is shifted, well, I'm just giving your lordship an analogy, has shifted from the owners to the occupiers, well, is there any rationale in saying that the owners will maintain the building and the occupiers will have no responsibility? So, well, if your lordship wants, we can give notice. We are the plaintiffs in the suit. We can give notice to the trustees or the Shebayats, so to say. If your lordship thinks that they should be heard, we can put them on notice. So far as the formation of association and maintenance of the building is concerned. And then your lordship can hear their stand, and then if they wish to join or maintain the building, we have no objection.
Lord, Lord, if my learned friend has concluded, my lord, may I only just, my lord, I came in a little late. I was hearing my learned friend, my lord, he was saying that we have consented. My lord, your lordships will recall by your lordship's order of November 2016, my lord, your lordships had permitted us to take objection or exception to the report filed by the special referee on the grounds that, my lords, we were not agreeable to form an association without the entirety of the dues which has paid to us. My lord, the dues run up to almost about 2 crores odd rupees. My lord, the reason I say this is because all the way from, my lord, my lord, I will not come to the money payment yet. The legal impediment that we are facing, or in fact all of us will be facing, is that the property is a trust property. Lordships are aware in terms of Section 13, Section 15 and Section 34 of the Indian Trust Act, my lord, the trustees are to manage the property of the trust. My lord, of course, my lord, we are managing the trust because with the consent and concurrence of the trustees. My lord, if your lordship so desires, I'll take your lordship through the power.
What steps you have taken?
My lord, I have, my lord,
What steps you have taken? They have filed this suit.
Yes.
You are telling that they have not paid the amount.
Yes.
You are telling they are telling that it has
My lord,
not been
I
paid.
have those emails where
What about the what steps you have taken?
Lord, I have written to them. I have written to them diverse occasions to clear these amounts because, my lord, we are not.
Okay, you have written
Yes.
to them. Thereafter, what steps you have
No,
taken?
my lord, may I just say this? I don't wish to if I say I will not pay you, his step is what? He has to file a money suit.
Yes.
So I'm coming on that.
Yes.
If
My
you
lord,
issue
yes, absolutely. My lord, your lordships are correct. My lord, I will have to independently file a suit because I cannot pray for reliefs in this suit. Your lordships are absolutely correct. My learned senior friend is correct. However, my lord, insofar as the orders which your lordships will pass of formation of an association, my lord, that can only happen when the trustees consent. My lord, your lordships will recall when your lordships were asked us to find a way to settle the matter. My lord, we had met. We had met and we had put our terms forward because we, under the trustees, are managing the property itself. The trustees have given us that authority to manage the trust property, and there are reasons. The reason is the property is a trust property, it is a commercial property. My lord, I am enjoying approximately 135,000 square feet of the entire area, which approximately boils down to around 75 to 80% of the entirety of the property. My learned senior friends, they occupy 20% of the property. That is the reason the trustees have entrusted us with the responsibility of maintaining the trust property. And your lordships will see from the lease deed, which is a part of my objection, Lord, that in case of any kind of breach of the lease, including the repair works or any of those, Lord, I am to be held responsible. My learned senior friends, they come.
Okay, I am issuing the notice to the trustee.
Lord, no, Lord, that perhaps will not be required.
Why?
Lord,
I am
because
issuing the notice.
I'll tell your lordships why.
As per your objects, sir.
Now he
No,
will direct
I
the
will.
court what
No,
ought
no.
to pass.
Lordships will kindly have a look
Kindly
at the
come to
power of
paragraph
attorney.
Paragraph 7.
Yes.
Kindly come to the paragraph 7.
Yes, my lords.
This is only your objects, sir.
No, I have another objection is that I have been entrusted
That's
to
why you
appear
have been
on behalf of the trustees. My lord, I have that power.
But
Lord,
you're not coming to settle the issue. Let the trustee become, or you.
my lord,
You
I am
take
here
one
to.
stand.
Yes.
You take one stand.
Yes.
Either you will act on behalf of the trust.
Yes.
Or this court can issue the notice on the
My
asking
lord,
the
I am
trust
acting
that
on
this
behalf of the trust, and that on.
why this has been given paragraph? Kindly read the paragraph.
Yes, my lord, may I read for your lordship's kind concern?
Yes.
I state that the question with regard to formation of any association pay the suit premises at the instance of the plaintiffs does not and cannot arise, since the suit property premises is a trust property and the management and administration of the trust property is required to be done at the instance of the trust or its authorized personnel.
Yes,
in terms of the instrument of trust. Lord, that is my respectful submission.
So if you are having the total
Yes.
power, so why?
Lord, I do not have the total power. My lord, the total power is me approaching the trustees saying that because I am there, because I have been authorized, I wish to take everyone in the premises into confidence and form an association.
Correct.
My only objection is that this order of formation of an association in my absence perhaps cannot be sustained in view of the fact that the property.
Who is telling that you go out of the court? I am giving hearing to you. How you
Yes,
can say
Lord,
in your
I am
absence?
saying that without clearing the dues which my learned friends have paid, there's
Sir,
a
you can put that burden to
condition.
the court. The
Lord,
court,
I am.
it is a court order. If
Yes.
the court find this,
Yes.
that all the dues can be recovered after the association is framed, what?
My lord, your lordships will see kindly see prayer see.
Why the
My
association
lord,
is
because
to be formed?
my lord, prayer see
Why
of
the
the.
association is to be formed?
My lord, the
Not
also.
to initiate a picture all over there, not to
No.
open the picture all.
Lord, their prayer.
Only to
My
maintain the
lord,
property.
prayer see of their plaint. Your lordships will see. They've said nothing is due and payable.
The court is not going to the pair C on the court is not deciding the total issue only for the interim measures for the purpose. That's why.
Lord, that is the final relief they've claimed in the plaint. Kindly seize the plaint. They have asked for formation of association as a final relief.
They have formed the scheme. Let the association be formed. Let one of the person, secretary and whatever the executive members come and let them say, yes, we have continuing with the work, then automatically the suit will proceed. If it not, then the case will proceed.
Lord, but then they'll have to give up prayer C where they say no amount is due and payable on account of maintenance charges.
You are telling that in both the hand, hot and cold, you want both the things. First association is to be formed.
Yes.
Correct. When the association,
Lord, my
when the association is formed, a resolution will be there. Tenants will present. Then you will say, ki, yes, this is the amount. If
Lord,
they will
can
deny,
that, Lord, very respectfully,
if they will deny, then the association will take appropriate
Lord,
steps.
very respectfully, can that or can those orders be passed in the suit which
Lord,
they have
kindly
filed?
let him read Press C. Let him read Press
There,
C.
there.
Don't mislead court. Kindly read Press C. I'll read for your lordship.
That's why the special officer was appointed.
Yes.
Let an special officer has given a good report, but now after submission of the report, you have violated. You are telling that no, I am not, because as per the special report, you are present in the meeting. You are consented for
No,
that.
my lords, my consent is conditioned upon the payment of the amounts which are due to me. My lord, that is conditioned. Kindly has a look at the.
What is the stage of the suit?
My lord,
What is the stage of the suit?
my lord, they have not filed written statement.
So let it be undefended suit. I will take care of
Very
it.
good. And my lord, kindly pass necessary orders on this interrogatory application. My lord, your lordship has heard the parties. My lord, kindly pass necessary orders.
Let the suit be undefended.
Lord,
And I will
my written statement is filed. Like my learned senior friend needs to take instructions on this. My written statement is on record.
see, if you are appearing for all parties, come to settle the dispute.
Lord, I am not appearing for all the parties.
No, you are the creator.
No, I am
Your
not.
client is creator.
Lord, that is
Problem creator is your
perhaps,
client.
Lord, perhaps that is not the correct.
That's
my lord,
the correct as per the as per the exception you filed it.
Yes, my lords, I have taken exception to the report on the ground that the
What report has been filed? You tell me what report has been
my
filed.
lord, that an association has to be formed.
Then
My lord, but the association should only be formed according to us once the dues of my lord,
okay, in that case, I am calling the trustee.
Lord,
I am issuing the
correct,
notice to
correct.
the
Lordships
trustee.
will do
If
that.
the trustee
Lordships
will
will do
say,
that.
we want
Lord,
this amount.
I'll tell you
and,
lordship why.
and your lordships will also kindly
Because
have a
the
look at prayer
day-to-day
C.
problem.
My lord, my learned friend says that I'm misleading the court. Kindly has a look at prayer C. No, my lord,
I
please
will
read
call
it out
the
for your
trustee.
May I?
What
May
is
I
the
read?
name of the trust? Give the name of the trust.
My lord, kindly, yes.
Give the name of the trust.
I'll tell you lordship the name of the
Lord,
trust.
Raja Rajendra Mullik Bahadur Trust.
Your lordship will find that at page 50 of the exception. Page 50 of the exception, your lordship will find the lease deed. This is the both to the trust property, and my lord, the surviving trustees be given notice, or the trust office, we can give notice to the office of the trust.
Trustee is there.
Yes,
Lords,
yes, my
Lords, I am.
Yes.
Lord, may I only say, my lord, can I show only one document to your lordships?
What document?
My lord, the power of attorney which is granted in my favor.
But you are acting more and above the power of attorney.
No, my lords, kindly.
That's why I am asking. I want to hear the trust. What is the view of the trust?
Lord,
let me see.
let-
Let the trust come.
Very
Without any power of attorney. Trust should come. Without any power of attorney.
My lord, kindly, my lord, only one thing. My lord, may I only say one thing?
From your submission,
My lord, may I only
understand.
my lord, may I
what
only
is
say
your
one?
intention.
My lord, may I only say one thing? My lord, only one document I'll show your lordships. Only one. After that, I'll rest my case. Only one document. My lord, may I? My lord, kindly has a look at page 14 of my exception. Kindly has a look. Perhaps this. Yes, my lord, page 14 of my exception. Kindly has a look at. My lord, this is the power of attorney in my favor. My lord, kindly has a look at page 19. My lord, kindly see the authority which has been given to me. Page 19, clause 4.9. And my lords, only one more clause I'll show.
What
I'm
is
not placing.
What is written in the 4.9?
My lord, 4.9, in terms of such and such, had granted power of attorney on so and so due to sudden demise of so and so, become trustees of the said trust. Power of attorney in favor of the above named trustees, which were granted in favor. Accordingly, this power of attorney is being granted, enabling them to take possession, surrendered. One more provision.
Read on, please read on.
Surrendered from the
Necessary
property.
power in connection with the said
Yes.
property.
Schedule B.
Described in Schedule B.
Yes.
Correct. Then
Yes. Now,
Page
my lord,
24,
fine.
your schedule
My lord,
please, page
reading
24.
on further, my lord, page 22 kindly has a look at. Page 22, clause 7.10. To prepare, sign, and file declarations, applications in connection with holding of the property. My lord, 7.11, legal proceedings. My lord, perhaps this will, my lord, not require
My lord, if your lordship so desires, my lord, let the association be formed, but this question of payment, let this be kept open. Let this question be kept
Whether
open.
the court is going to decide the payment.
No, not in this suit. Not in, let the association which is to be
Court
formed.
is going to.
Yes.
What submission you are making? Whether the court has opined anything with regard to the payment, only the court
No.
is telling that with regard
Association.
to the association for the purpose of maintenance of the property in
Yes,
question.
yes.
Nothing else with regard to the rent, with regard to the tax, that is to be decided by the association.
Yes, my lord will only
I'll
provide
show
for
you,
that.
Lordship, my lord.
Lordship will only
The
provide for that.
mischief in the stand of the defendant, I'll show you. My lord, kindly take page 24 of the power of attorney. He's referring to the power of attorney. Kindly come to page 24. So the power has been given with respect to Schedule B. My lord, kindly see what is Schedule B. Office space having a carpet area of 5,200 square feet on the ground floor in the building such and such, then your lordship will kindly turn. Office space 400 square feet, that is number 2. Then office space 22,000, more or less on the 4th, 5th and 6th floor. Now your lordship will kindly turn. Para 4, para 5. So he has been given power of attorney to do whatever is necessary for the purpose of the restricted area for which lease has been granted to him. So what about the rest of the building?
That's why he is restraining the court to issue notice to the trust.
And the
That
trust,
will open a Pandora box for them in other suits also.
That's why he is
So
restraining
how many trustees are there or not?
the
let
trust.
necessary orders be passed, my lord. Your lordship can
Yes,
understand
kindly
what
come
is
to the page,
happening.
Yes.
Schedule B,
Yes.
paragraph 4.9. Schedule B is your
What
property.
he's doing is he's acting beyond his power and beyond the lease. Because even if he says he has 1 lakh square feet, the entire building is more than 25 lakh square feet. So now he's in control of the remaining 24 lakh square feet. And he wants power and he's earning from there. That's the real
Lord,
thing.
my learned friends do
Again
not.
and again, he is asking the money.
Yes.
Lord,
I am sure,
Lord,
my lord,
obvious,
my
Lord, it's a
nobody will
commercial
stop him.
property. It's a commercial
My lord,
property.
we will
2 crore
not
rupees is
mind.
left.
You have let out.
My lords.
You have let out.
Lord,
You have let out the property to the tenant.
yes. Yeah,
You
Lord,
have
not to
let
him.
out the
Not to
property.
him. The trustees have let out to me.
then
The trustees
where-
have also let out to him.
Where is the trustee given the power to you against them?
Lord, not why, Lord.
Lord, all I
They
will
will-
say is that, my lord, we will not
Where is
mind
the power
defending
of
one more suit.
attorney? The trust
Let him
has
file the
given
suit,
the
we'll
power
defend.
of attorney to you to take appropriate steps against them for recovery of the all dues.
Lord, by reason of the fact that the entirety of the property is
Okay,
out of.
I will decide this
My-
exception on merit.
My lord, my lord. Kindly decide it and pass necessary orders. Grateful, man. Grateful.
Hearing counsel
Great,
for the front
great,
to front
grateful.
are present. Full stop. Counsel for the defendant number 1 has filed exception to the report filed by the commissioner appointed by the court. Hearing concluded, fix for orders.
Grateful, my lord.
I'm
Keep your place.
नहीं देखेंगे ना नहीं दो
My lord, I beg to appear for the defendant, my lord. Where is their application?
আমার বিপদ উঠায় গেল Yes, Mr. Manager, you will take. Who will argue?
My lord, it's,
Lord, I
I'm
will
learned
take time.
senior friend was arguing.
It will take time, and you will continue.
I will continue, but Lord, I maybe
That's why I have not released.
Lord, almost Lord 60% I have already on the earlier occasion. A few points are there. I want to conclude that part.
Sir, I've been led by Mr. Singh.
Lord, facts I may not, I may recapitulate the facts. Nirod Bihari, Lord, was the owner of the property. Nirod Bihari Lahiri. Lord, who had executed and registered a lease for a period of 15 years with option of 5 years renewal on 4th of October 1951. Rent at the rate of 300 per month payable according to English calendar. Now, Nirod Bihari, Lord Lahiri, Lord, therefore, the lease that has been expired, no option of renewal was made. And then, initially, the plaintiff, what was it, 10-12 shares? 10-12. 10-12. Yes. Out of Lord 10-12 shares, Lord, he purchased the property. My client purchased the property. That is plaintiff number 1 purchased the property and filed a suit for recovery of possession. Lord, on the ground that tenancy is governed under the West Bengal Premises Tenancy Act, but lease was for a period of 15 years with liberty to renewal for 5 years. Now, Lord, thereafter they have taken a point that he did not take any consent from the other co-sharers, therefore suit cannot be filed by 10-12 co-sharer holder. That suit was dismissed initially, then appeal was preferred, appeal court restored it. We are entitled to file it. Even a co-sharer can file the suit. Subsequent development has been made. That development is the remaining co-sharers again have sold the property. Therefore, they have already been added as a plaintiff number 2. Plaintiff number 2. Therefore, now, my Lord, plaintiff number 2 became the absolute owner because plaintiff number 1 has also
2 to 5.
2 to 5. Plaintiff number 2 to 5 is also also owners of the absolute owners of the property. And plaintiff number 1 also transferred the property to the plaintiff number 2 to 5. Now, plaintiff number 2 to 5 has stepped into the shoes of the entire 16 other shareholders. Now, having regard to these facts, Lord, there was an amendment. Lordship, kindly look to the amendment. Amendment of the plaint. Let's start with it. Your amendment of the plaint was made.
Paragraph K.
Yes. 31A, my Lord. Page 28.
A.
Lord, page 28, my Lord, of our application.
32A.
32, yes.
Correct.
31A, my Lord.
31A.
32A.
32A.
31A, my Lord.
Initially 31A, second amendment 32.
Plaintiff alternatively states that the lease deed dated 4th of October 1951 expired by flux of time long ago. Nevertheless, the erstwhile lessee, Madan Lal Poddar, since this is intentionally and with due knowledge of the said conditions of the said lease, did not dislodge, remove, or take away any or all the erections, material set up or created or brought up on the suit premises within the stipulated period of 3 months after the expiry of the lease or even thereafter, and by reason of payment and acceptance of rent monthly in respect of the land only, and after expiry of the said lease period, the said erstwhile lease remained monthly tenant by payment and acceptance of rent for vacant land only, governed under the Transfer of Property Act. Notice of ejectment was duly served upon the defendants, but the defendant did not vacate the vacant land, being the suit premises, by removing the structure therefrom, that by virtue of the deed of transfer executed and registered in favor of the plaintiff by the 10th shareholders of the suit premises, the plaintiff has become fully entitled to evict the defendant from the suit premises. Defendants have got no right to occupy the suit premises after demarcation of monthly tenancy, determination of monthly tenancy by notice to quit in respect of the bare land in question. The defendant, despite receipt of the notice of ejectment, neither removed the structure or building nor handed over the vacant land unto the plaintiff. Hence, the plaintiff is entitled to have the ejectment degree against the defendant. Number of notice he accepted and served. That part I can place before your lordship. In their written statement, they admitted that Lord, in the written statement, Lord, they admitted that the notice was duly served on them. Lord, lordship, kindly come to the written statement at page, Lord, 44 of our application. Lord, first of all, page 46, paragraph, Lord, subparagraph C. C.
But before your lordship release the other matter আপনি পুরোটা চলবে 4:30 অবধি
আপনি চালাবেন আমি 15 মিনিট আর নেব
I may not start today my lord. My learned friend is let him
how much time you will take? I may take judgment গুলো তাহলে লাগবে oh yes
then it's okay. I thought it will come on me that I wanted to
That's why before that the advocates are asking. So I am not released. I asked Mr. Banerjee. So but he said but then I stopped that. Now I see the flow of Mr. Banerjee. It may continue.
Then it is fine.
In
item number 3, I will just be making this seeking short directions in the matter, my lord. May I wait, my lord? I do not know if the
Okay, you wait, then I will pass.
My lord.
Yes, continue.
Lord, your lordship,
I'm very sorry. Lord, I'm very sorry, Lord. Item number 4, Lord, my other side is here.
I will take. If any person wanted, then I will take after this. Very good. Yes. 46 para C. Para C.
Para C, by registered deed of leave, dated 4th October 1951, this said Nirod Bihari Lahiri granted a lease in respect of the said premises in favor of the said deceased for a period of 15 years with an option for a further period of 5 years commencing from 1st of September 1951 and ending on 31st of August 1966. Copy of the lease deed is this is admitted. Therefore, relationship between the lessor and lessee, Lord, is admitted fact on record. Now, Lord, lease in respect of the vacant land, bare land. Lordship, kindly look to the lease, because before that, I may place before your lordship the notice which they agreed to serve. Kindly come to E. After C, my lord, E, page 47. This deed of lease dated 4th of October 1951 further is stipulated as follows. All buildings, erections, structures.
Come II. Come to the II. Come to the II.
II, yes. On or before the determination of the tenancy, said deceased shall at liberty to dislodge, dismantle, remove, take, carry away for the use all buildings, erection, bungalows, workshop, sheds, structure, plant, machinery, and appliances set up, erected or brought in upon demised premises or any part thereof. Now, Lord, admittedly, Lord, according to the admission is that according to the defendant, the lease was executed and registered, lease was expired, and their defense is that is holding over. Defense is substantially, my lord, not in so many terms, but they say holding over. Kindly come to the paragraph.
That you already pointed out.
Already I have pointed out, judgment I have delivered. Judgment I have given to your lordship.
I taken note of it.
Yeah, already your lordship has taken a note of it. Now, my lord, therefore, substance of the case is that the lease in respect of the bare land on which that lease was expired. The renewal clause was there. Renewal clause was there. He did not exercise the renewal. Lord, the argument which I have advanced on the earlier day, only one sentence, that if the renewal clause is there, then question of holding over does not arise. Because 2005 I have given that judgment. Therefore, that defense goes. Now, what is remained is that according to the defendant, that I have raised a building thereon. Therefore, I am the owner of the building. We say that decree may be passed in respect of the bare land, subject to them.
So what will happen to the building?
They will remove the building. They will remove the building because the law is, yes, that is I wanted to play.
2015.
Yes, that is 108.
By the
108.
There is no admission now. Now it's going
No,
to
there
be-
is admission.
Now this is
Admission.
very-
Lord, the question is,
ছুটি হবে, দরকার কি আছে?
ওটা আপনি বলছেন, ওটা আপনি তো বলবেনই, আপনি বলবেন, আপনি বলছেন যে ছুটে হবে। Lord, the whole question is, my Lord, that principles of Lord Order 12 Rule 6, my Lord, principles are that if in substance the defense is not cannot succeed, and there can be no question of trial for the purpose of adjudication of the issue raised. What is the issue raised? Holding over. Under the law, not tenable. Number two, so far as the building is concerned, he raised it in terms of the clause of the lease, he is bound to remove it. Now, law answer is, he is bound to remove it, for which no adjudication is needed. The line of judgment I will place before your Lordship, that if no adjudication is needed, and if there is a chance of passing a decree in favor of the plaintiff, then in that case, within the meaning of otherwise, admission or otherwise, within the meaning of that, what would be the meaning of otherwise? The line of judgment of the Supreme Court is that otherwise means that from which other documents pleading admission is there, from other documents there may be admissions. Number three, from the defense, tenor of the defense, it appears that there exists no defense at all in the eye of law, then court is entitled to pass a decree.
Okay.
And this is the otherwise meaning. Therefore, test is the defense which they have raised, whether requires adjudication
or admission
on facts, or it can be answered purely a question of law. It can be answered in law, and there exists no question of adjudication of the issue. In that case, within the meaning of otherwise, court is entitled to pass a decree on admission. Lord, that is my whole aspect of the case. Now, Lord, your Lordship, then another thing, Lord, another thing is that in which that with regard to receipt of the admission of the notice, because adjudication may be there if service of the notice is disputed issue. In that case, adjudication is needed. It is not a pure question of law. One is legality of the notice.
Disputed question of fact.
No.
If that notice is denied.
Yes, disputed question of fact. Then in that case, adjudication. But he admitted that notice. But question would be that notice is not also required under the law, because the 15 years lease has already been
Lapse of
expired.
time.
Yes. Therefore, that is also not required. Now, my Lord, that admission part, your Lordship kindly look to that. ওই জায়গাটা দেখে দিন যেখানে ও admit করছে। Page, my Lord, 93. কোথায় 93? Oh, yes. No, ওরাও স্বীকার করেছে তো। Lord, this is the notice which they have received. This is the notice, page 93.
Yes.
Which they have received. Which they have received, and that was annexed. এটা কার সাথে annexed করেছে? না না এটা কার সাথে annexed করেছে জবাব yes this was annexed in the with the written statement the notice they have received it then my lord your lordship then kindly come to page 69 না না এখানে admit করেছে বলো but page 62 my lord of the written statement now notice the page
Yes.
paragraph my lord 20 with reference to the allegations contained in paragraph 21 and 29 of the said plaint, it is denied that the defendants are causing hindrance or obstruction so and so by keeping large size mobile oil in containers with all articles therein causing annoyance and nuisance into the plaintiff and other occupants of the premises as alleged. Said allegation also contained in the notice issued by the advocate by the plaintiff, which has been duly replied to by the defendant through advocate's letter dated so and so. Therefore, it was, and that was annexed. Therefore, it was received by them. And page 69, my lord, annexure, that has been annexed.
Yes.
Now, Lord, next point is that after the amendment was made, Lord, this is the amendment part 13. Lord, page 32, after the amendment was made, they did not file any
Written statement.
additional written statement. Therefore, it shall be deemed to have been admitted by them.
That you are-
Now, Lord, only question is whether Order 12, Rule 6 shall be read with Order 6, Rule 5. Supreme Court said yes, it can be read with that. Order 5, Rule 8. Order 8, Rule 5. Order 8, Rule 5. That should be read with that. Because so far that part is concerned, they didn't deny it. Therefore, my lord, I am the owner of the property. They are not the owner of the property, admittedly. They are the tenant. They are the tenant, erstwhile tenant. That has been expired. Now, my lord, with regard to his case is not that he is a tenant governed under the transfer of under the tenancy has
Tenancy
been
Act.
newly created. His case is that by holding over, that is not tenable in the eye of law. Then what right he has got, my lord, to occupy the property?
Okay.
Now, my lord, the question remains: what about the
Building.
Building? Now, my lord, the answer is civil পদ্ধতি এটা TP Act. Lord, section 108, subsection 8. Lord, 8. The lessee may, Lord, 108, section 108.
Subclause H.
Lord, 108. In the absence of a contract or local usage to the contrary. Therefore, here the contract is, they are to remove it. Lord, contract in the lease.
Yes, you on the last occasion you argued.
Yes,
That
yes,
date,
that's
subclause
right.
HI.
That's right.
Subclause
H.
H.
H. H. Lordship, kindly come to H. The lessee may, even after the determination of the lease, remove at any time while he is in possession of the property lease, but not afterwards, all things which he has attached to the earth. Lord, this has been interpreted by the Supreme Court, not afterwards means that decree is to be passed in respect of the land with direction him to remove the structure.
Whether that is under Order 12, Rule 6 or on merit.
That is under Order 12, Rule 6.
Order 12, Rule 6.
Order 12, Rule 6. Because, my lord, because he has no right to retain it. In terms of the contract, he is bound to remove it. Adjudication is not needed. Posted test is whether adjudication is needed. Defense taken whether adjudication is needed. Number one. Number two, adjudication is always needed. Inquiry resolving the dispute is needed. adjudication in all the cases, Lord, in the case of Order 12, Rule 6 also to be made by the court. Question is controversial dispute, factual matrix to be decided on evidence, whether that is required. Trial on evidence is required.
No, if the disputed fact is there, with the court find that it is required to be decided trial, then no decree can be passed.
Right. Absolutely, my lord, right. This is exactly my contention, my lord, so far that part is concerned. Now, my lord, 8 is substantially, 8 is said that contract is otherwise. Therefore, when contract is otherwise, they are bound to remove it. Now, my lord, according to my plaint, another thing, according to my plaint, Lord, there are two prayer. One is, Lord, that he is a tenant governed under the Premises Tenancy Act. That he did not admit. And second case is that he is that is a tenant governed under the Transfer of Property Act. Lease has been expired, and we are pressing that case. Based on that, our application under Order 12, Rule 6. Therefore, we need not go into that question whether he is a tenant governed under the WPPT Act or not. I'm Lord, surrendering my case by saying that this is my positive, this on the basis of my amended plaint. Lord, I am praising that only for the purpose of Order 12, Rule 6 of the Code of Civil Procedure. Lord, now, Lord, the judgment. এদিন আমি যেটা দিয়ে দিয়েছি আমার যেটা আছে আমি যেটা নোট দিয়েছি সেইটা আমাকে কালকে যেটা দেখিয়েছিলেন কোনটা দিচ্ছেন আপনি Yes, Lord, 2000 volume 7 SCC. First of all, Lord, 2000 volume 7 SCC, page 120. 2000 volume 7 SCC, page 120.
Uttam Singh Duggal.
Uttam Singh Duggal.
Paragraph 12.
Yes, my lord. Paragraph 12, my lord. Paragraph 11 also.
11 also.
Lord, the paragraph 11.
Yes.
Admissions and the judgment on admission could be given only after due opportunity to the other side to explain the admission, if any is given. Then such admission should have been made only in the course of the pleading or else. The otherwise we will not have an opportunity to explain such admission. But even though provision reads that the court may at any stage of the suit make such order as it thinks fit, the effect of admission, if any, can be considered only at the time of trial. That the admission, even in pleading, will have to be read along with Order 8, Rule 5. But my submission is that Order 8, Rule 5, the amended portion, that shall be deemed to have been admitted. Now, even if defense case is accepted, even then, no trial is necessary. And the court need not necessarily proceed to pass an order of a judgment on the basis of but call upon the party relying upon such admission to prove its case independently, that during pendency of other suits and nature of contention, it would not be permissible. My lord, this is the argument advanced. Learned counsel advances argument, as has been done in the present case, that expression admission in the courts of, because this would be the argument by Mr. Sen. The answer is given as to the object, paragraph 12. As to the object of Order 12, Rule 6, we need not say anything more than what the legislature itself has said when this said provision came to be amended in the object and reason set out while amending this said rule. It is stated that where a claim is admitted, the court has jurisdiction to enter into judgment for the plaintiff and to pass a decree on the admitted claim. The object of the rule is to enable the party to obtain a speedy judgment, at least to the extent of the relief to which, according to the admission of the defendant, the plaintiff is entitled. We should not unduly narrow down the meaning of this rule. So as the object is to enable a party to obtain a speedy judgment where other party has made a plain admission entitling the former to succeed, it should apply. And also, wherever there is a clear admission of facts in the face of which it is impossible for the party making such admission to succeed.
Yes.
Then, my lord, paragraph 16. Lordship, kindly come to paragraph 16. The learned counsel for the appellant relied on a decision of this court in so and so case as to when an admission becomes relevant, which is locus classicus on the subject states that merely because a written admission is made in a different context, such admission may not become relevant if the party making it has a reasonable explanation for that. But that is not the position in the present case at all. Learned counsel for the appellant further adverted to the decision in so and so in which the court was concerned with a case to the effect of non-filing written statement and whether the decree could be passed only on that basis. That was a suit for a specific performance, and it was held that it could not be granted without even writing a detailed judgment, and adverted to various provisions of the Code of Civil Procedure and reference under Order 12 Rule 6 by way of analogy, and referred to the dictum to state that Order 12 Rule 6 should be read along with the proviso of Rule 5 of Order 8. In that case, what was noticed was that in cases governed under Section 42, the case is not bound to grant declaration. My lord, this is with regard to specific performance of contract. Therefore, my lord, the whole idea behind it, paragraph 17, whole idea behind it is, my lord, that if there exists, if the defense that set out is not entitled to succeed on the anvil of the law, then in that case,
correct.
If
the court find the defense will not serve any purpose in future in trial, it's automatic.
Lord, as per, I'm giving an example, Lord, Section 2G of the Premises Tenancy Act, that he has no right, 5 years expired. I file a suit for eviction. Now tenancy is admitted. No due tenancy is created.
Correct.
According to the defense case. Then court will say, no, I will go for a trial. In that case, court on the basis of this pass a decree. Pass a decree. What's test is whether even if the defense is taken to be accepted, even then whether it is entitled to succeed in the eye of law or not. That is, Lord, now Lord, next judgment. 2010, এটা কি জন্য দেখছেন হ্যাঁ 2010 Milord, volume 4 ACC, page 753. এটা কোন প্যারাগ্রাফটা দেখাবে
करम कर पाई करम कर पाई
Yes.
Thank you. Lordship is now knowing all this by heart.
Yes, yes.
Every day one case.
Yes.
Huh? Because these are the Milord celebrated judgment with regard to these aspects.
In every case.
In every case.
And
in every case,
Order
Milord,
12 rule, Order 12 Rule 6 or Chapter 30.
That's 13. Yes, yes.
This
Yes.
5-6 judgment are there that is repeating every day.
Repeating. But now your lordship kindly look to the paragraph, Milord, 44, Milord. Uttam Singh, Milord, has been quoted. ওই জায়গাটা দেখে কিন্তু আদারওয়াইজ এই যে যেটা বললাম না প্যারাগ্রাফ বলুন তার ওখানে Lord, it is practically the paragraph 37, 38 onwards, 37.
Yes.
Lord, paragraph 41, I shall argue, Lord, on this, keeping the width of this provision of Order 12, Rule 6 in mind, this court held that this rule, admissions can be inferred from the facts and circumstances of the case. This I am stressing regard to that part. And Delhi High Court's judgment, I think. And paragraph 43, my lord, that is Uttam Singh Dugal's case.
That has been described. Yes.
That has been dealt with. And the meaning of otherwise that has been given.
Yes. Next.
Only relevant portion I will read before your lordship. In a state of reading from the
Relevant. What are the?
Yeah, only relevant.
In your case.
Yes.
Now then, Mr. Sen will distinguish that how it is.
Yes. And paragraph 48. Lord, the extent of the power, paragraph 48. Lord, we have doctrine of election. Lord, we have elected the amended part.
Yes.
We have elected the amended part.
Which they have not dealt with.
They did not deal with.
There was no deletion.
And Lord, your lordship knows that if contradictory case is made either in the plaint or in the written statement, the election is to be given either at the time of trial that what case you are to make out. Because contradictory case cannot stand
in both the legs.
Cannot stand. Therefore, in that case, election is to be made first before the trial begins.
So that is the issue.
That is the issue.
That is the issue. So the issue is to be seen.
No,
which defense he wanted to continue with the by framing up issues.
No, therefore, my submission is that I say that tenancy is governed under the WBPT Act. They say tenancy is governed under Premises Tenancy Act. My election is that I am not making out that case. I am skipping that case.
No, that is.
I am surrendering that case. And I am restricting on the basis of that case.
That's why once earlier when you have filed the suit, you have made out some other case.
Yes.
Subsequently, after this execution of the sale deed, you have made out another case.
Yes.
Now you are harping upon the paragraph 31 and 32.
30. Based on that. Therefore, my lord, whatever issue is framed, that issue need not be dealt with on the basis of the admission on the part of the defendant.
As they have not filed the return statement.
Yes.
Deemed admission.
Yes.
Next.
আরে দিল্লিটা দিন না 50 ঘন্টা দিয়ে লাভ নেই দিল্লিটা দিন আমার কাছে দাগ মারা আছে যেটা দেখুন তা Lord, now I may place before your lordship one line Delhi High Court judgment. Paragraph my lord 29, 29, 30, 32, 29. 29, it is settled law that Order 12 Rule 6 is an enabling provision that confers discretion to the court for ensuring speedy justice on admission to the extent of the claim admitted by one of the parties to the opponent's claim, as noted above. Such admissions can be in the form of a pleading or otherwise, that is in the documents, correspondences, etc., placed on record. It can be oral or in writing. The admission can be constructive admission as well as without it being specific or expressive. Constructive admission. Constructive case. Correct. Whether he has a right to occupy the property, which can be inferred from vague and evasive denials in the written statement while responding to the specific pleas taken in the plaint. I must state that the appellant defendant has relied upon the judgment which have been referred to above. There is no dispute with regard to the proposition laid down in the judgment, inasmuch as 1. A judgment on admission under Order 12 Rule 6 of the CPC is not a matter of right, rather is a matter of discretion of the court. 2. To constitute a clear, unequivocal, unambiguous, unconditional admission, the trial court has to see the overall effect of the pleading and the document.
This is the main ground under 12 Rule 6.
Right. Overall effect.
Overall effect.
That is why, my lord, I argued overall effect. Overall effect.
Unambiguous and unequivocal.
What right you have? For a judgment on admission to be passed, the court has to see as to whether admission of facts is plain, ambiguous, and unequivocal, and go to the root of the matter, which would entitle the other party to succeed. Which would entitle the other party to succeed, whether his defense can succeed or not.
Mixed question of law.
Yes.
Mixed question of fact.
If the issue raised involve a mixed question of fact and the law, same shall be adjudicated by way of evidence.
Yes.
But this is the only test.
That's why if it is a disputed question of fact and law,
Yes.
then it is to be go to the trial.
Then, my lord, paragraph 30. From the reading of the aforesaid judgment, it cannot be disputed that Order 12 Rule 6 can also be invoked when objection raised against the rendering a judgment as such, which goes to the root of the matter, or whether objections are inconsequential, making it impossible for the party to succeed if it entertained. That is, I am, Lord, harping my argument on the, even if, Lord, his defense is accepted, whether it is impossible to succeed or not. If it is impossible to succeed, then in that case it can be. In the case in hand, the appellant respondent has clearly stated respondent has let out the property to him. Lord, then this is the facts of the case. Then, my lord, paragraph 33. Paragraph 33, my lord, towards the middle. In substance,
yes,
the conclusion of the trial court is that defense setup was such as to make it impossible for a party to succeed, shall be a ground enough to accept the defense as admission and grant possession of the property to the other party. Lord, this is I am on. Lord, that's all.
Thank you.
Yes. Next day, sir. 1 minute ahead.
Suffering for the plaintiff, suffering for the defendant. Counsel for the plaintiff concluded his argument in connection with GA.
আমার আবার আপনার চলে যায়নি তো আমার দিক থেকে
GA 3 of 2011. 2011?
কালকে নেই তো
2011 is fine. 2011.
So many amendments have come thereafter.
Due to paucity of time, counsel for the defendant could not
commence the argument. Let the matter appear on. Bapre. Then again. Then again, Mr. Haradan will repeat.
The 22nd January, that week, your lordship can omit and take it after that.
Prior to that, there is no time. 11-12 नहीं है कुछ 10-11 ना 11-12 जनवरी का नहीं 29 January what time 3:45 not before that 3:45 risky
Very risky. 29.
what time 31st January 12 noon
Yes.
Well,
31st January,
Well, I-
12 noon.
12 noon
Item number 3, if your lordship can give us 1 minute, my lord.
yes
Well, this is a suit by the Union of India, my lord.
Hmm.
Well, there is some confusion whether this is a contested suit or a undefended suit, my lord. Because I was previously engaged in the matter. Then again, due to change in panel, I was not there. Now I am again being re-engaged, my lord. Well, this is a simple claim for money on the basis of firstly an agreement, secondly on the basis of the undertaking given by the
affidavit department railway
no, my lord. This is Ministry of Shipping, my lord.
Shipping.
No, Ministry of Chemical and Fertilizer, my lord. This relates to a shipping contract, my lord.
Okay.
The agent was given, and the agent
shipping contract
well, agent, my lord, handling agent was appointed. The defendant was the handling agent, my lord.
Hmm.
Now, my lord, there was a claim for demurrage raised by the ship owner.
Yeah.
As per the agreement, my lord, you lord should come to page 41, my lord. I'll just make it as short as possible. Page 41, my lord. This is a part of the agreement, my lord.
so now what you want
My lord, I was saying, my lord, whether the officer is to the present, my lord. So either, my lord, we will invoke order 12 rule 6. I do not know whether this is defended contested suit or an undefended.
how many dependent soul how many dependent
One dependent.
whether the writ of summons was served upon the defendant
Yes, my lord. The writ of summons was served. They had filed an application under Order 7, my lord. That was rejected. Possibly, my lord, written statement was not filed.
that might be in the interrogatory whether the writ of summons was served have you obtained the report
It was done at that time. I was appearing, my lord, but they appeared, my lord. They appeared. There is an order of an appeal court directing them to file written statement.
okay
My lord, written statement copy in my records I find. But whether that written, possibly it was not accepted, my lord.
it is there
My lord, it was possibly not accepted. The matter was possibly appearing as an undefended suit, my lord. It's a very long time, my lord. Because they appeared on the last date, possibly. The previous date.
Return is promptly by 22nd December 2015. Yes, as per the leave granted by the court, 22nd December they have filed.
They have filed, my lord.
They filed the written statement.
My lord. Whether the case
is there in the for the defendant?
Nobody on the last. They had appeared previously
So
when.
I am passing an order for discovery and inspection.
Well, your lordship kindly hear out the merit for on the next date, my lord. If your lordship, even if discovery and inspection is required, your lordship, my lord, that is why I'm saying, my lord, page 41, my lord, clause C. Page 41, clause C.
41.
41, clause C. Entire demurrage accruing after berthing of the vessel, that is post-berthing demurrage, to be on the account of handling.
The berthing of the vessel, that is the post-berthing demurrage, will be the account of
My
the
lord.
handling agent.
My lord, now in this case, my lord, the demurrage was incurred, my lord. Now there is a department called Transchart, which decides the demurrage, my lord. It was decided that we had incurred this demurrage, my lord. Now, my lord, our agent said, no, you will contest this in an arbitration. We, no, that's the page, letter.
There any
My lord, page 59, page 59. This page 59, this is the whole basis of our. Page 59.
And even one thing,
whereby you
secondly,
confirm the matter should be referred to arbitration. We agree to bear the cost of arbitration and interest liability.
so why it has not been referred?
It was referred, or it came against us.
Why?
It came against us. Arbitration proceeding
Arbitration proceeding against you.
against me. So we are liable. We become liable to pay the money. So demurrage they have to pay as per the agreement, and they have additionally
No. Then what is decided in the arbitration?
that we have to pay the demurrage
Then
and the costs, my lord.
so why the suit?
But the suit now we want to recover it from our agent, my lord. Agent is
So you
agent advised us. We were ready to pay. Agent said, no, I will incur the
in terms of that you have paid the amount.
paid. Those are all bills are
Now
next.
that recovery is to be made.
That
from the agent.
recovery we told. Now they have set up one very small defense, my lord. They have said the original company was Shaw Wallace, my lord. Shaw Wallace was merged with United Breweries. When on the date when the award was passed, my lord, the merger had not taken place. Merger had taken place subsequently. According to their written statement, they say, my lord, the liability had not occurred at that point of time, but on fact it has occurred. This is their only defense. Otherwise, they have said there is no material defense, my lord. They have not.
That's why what I propose.
My lord.
See, anyhow, if you are not wanted to adduce, the case is depend on the document. So what I propose, they have filed the return.
My lord.
Correct. So I am passing an order for discordant inspection of short time, and you inform the other side.
My lord.
If they will come, it's okay. If not coming, then I will take your argument on the after the argument, the order can be passed. So the procedure, so that tomorrow they cannot come in after all of a sudden the matter is taken up for hearing.
Well, there is one small problem.
This company is still there.
No, my lord, the officer has come with the original documents. So, my lord.
Original document is not required. If you are on record, I didn't record any. If
No,
the
in
other party,
inspection on the inspection, they might demand to see the.
that's why they may you either you keep where from you came, Delhi.
From New Delhi.
Not any office is not here in
No,
Kolkata?
no.
Which department?
The Ministry of Fertilizers.
Because unless and until that order is not passed.
My laws will pass some order.
I pass an order. I
We'll
will
see.
you keep with you, or if they want, then you can bring for inspection. You can date it. If they are not coming, then next date if they will not come.
Yes.
Then your argument, you can make an argument instead of adducing evidence, and judgment can be passed on the basis of the document.
Great.
Or you want to, or I will take as the undefended suit, it can be taken. Concerns appearing for the plaintiff, none appears on behalf of the defendant. It is fine from the record. The defendant had already filed written statement. In view of the above, the parties are directed to complete the discovery and inspection of the document within 2 weeks. Within 2 weeks or 3 weeks.
2 weeks.
Within
3 weeks.
Within 3 weeks, comma. Within 3 weeks, full stop. Affidavit of admission and denial be filed within a week thereafter. Full stop. In the meantime, the parties are also directed to exchange their suggested issues. List the matter on 10th January.
10th January, my lord. 10th January.
Yes. 10th January 2024 for framing of issues.